Yes, Mr. Bakshi.
My lord, the petitioner is a promoter, my lord. My lord, under Annexure 1, the project has been started in a rural area in the year 2010. By that time, the RERA Act was not there and no permission was required. And under Annexure 1 series,
Have you removed the defects?
my lord, there is
Last order was very specific. The defects are identified shall be removed by the next date.
by
Mr. Nanda,
tomorrow I will.
I don't know. This is the way.
There is some defect in the Bhokladnama, that is capital letter.
I don't know what is the defects, but they say there are two.
I
defects are there.
undertake, I will by
We
tomorrow.
are fixing the matter on 11th of August. You remove the defect. 11th of August. At the request of Mr. D. Nanda, Learned Counsel appearing for the petition, let the matter be listed. 11th of August. It appears that despite our order dated 10/7/2023, defects are not removed. If by the next date the defects are not removed, this court will be persuaded to pass an order for non-prosecution.
Mr. Nanda, you check, many of the pages
are
have not been signed.
Legible and signed.
Sorry, ma'am.
Item 2.
You may please, Your Lordship. My lord, seeking an adjournment because learned senior advocate Mr. S.P. Mishra is appearing, would be appearing in this case. So I'm seeking
Is unwell.
pardon, my lord.
SP Mishra is unwell.
Senior advocate S.P.
Yes, he's appearing, so
Yeah, my lord, one date for accommodation, my lord. I could not intimate him. So my lord is.
The request made for Mr. SP Mishra and his senior counsel. What is your good name?
Nihal Rath, man.
The request of Mr. Nihal Rath, counsel appearing for the appellant. Let the matter be listed on 23rd, is all right? 29th August 2023.
Let him serve a copy of the read.
Meanwhile, the defects is identified by the registry shall be removed. There's the defects.
Let him serve a copy of the writ appeal.
Supply a copy of the writ appeal. We are not reflecting.
My lord.
It is not court's duty. Just in the course of the day, you supply a copy of the writ appeal.
Obliged, ma'am.
Yes.
Item 5.
None appears for the petitioner when the matter is taken up. However, Mr. Mr. M. K. Kuntial, an additional government advocate, appears for the state. By the order dated 27/6/2023, observed as follows, para 4. It is made absolutely clear that if on that day there is no representation for the petitioner, will be pursued to pass an order for non-prosecution. We do not have any other alternative but to pass an order for non-prosecution. This writ petition stands dismissed for non-prosecution. All right.
Item 6.
Lordship, may be pardoned to mention a thing, Lordships. I just got an information, item number 4 was mentioned and it has been adjourned to 4th of August, my lord. 3rd of August. But Lordship, I'm for the opposite party.
Respondent 1, sole respondent 1, my lord, I am the
My
opponent.
learned senior is not available on 3rd and 4th, my
This is
lordship.
for admission, Learned Counsel. It is
So may date be fixed after 3rd and 4th, any
No,
day.
no. It is between the court and the parties, whether we'll admit or not, let us decide and then your right will be there. All right.
Lordship, we have appeared through caveat.
Will not be passing in absence any interim order. What is the basic principle of the caveat? Tell us. Do you have any right if you
Yes.
do not pass any interim order?
No, my lord.
That's all that we look into that aspect. We have already passed an order.
Lordship,
And
Mr.
it is not on
Acharya,
4th of August, it is the 23rd of August.
23rd of August.
Yes.
I'm deep. My apology, Lordship.
No, it is the
My friend
23rd
told me
of
that's 3rd of
All
August.
right.
23rd, my lord.
Yes.
Deeply obliged, my lord.
Item 6.
Okay, George. The PIL matter, my lord. Petitioner challenges the order of the Tahsildar with regard to the construction of sub-center building under Usma Gram Panchayat over Khata number 1217 plot number 2627, which was reserved for the school, my lord.
Have you removed the defects?
Yes, my lord, I have removed. I have
Alright.
filed a type copy of annexure one. which-
All right. Is how you are affected by this annexure one. They are finding some place for construction of the building.
Subcenter building
Ah,
at a plot number where the plot is reserved for the school and also at a distance, my lord. The Tahsil
everything
BDO and
cannot be doorstep. The government need land, government needs fund, government needs road.
no, my lord, with the connivance of a report of the Tahsildar and BDO Sarpancha, they have selected a land which are appropriate for the benefit of the public at a large, which was annexed at Annexure 3 series. They have prepared escape maps and also prepared a land which will be benefit for the same. But instead of taking into account of the same land, the Tahsildar
Who is
arbitrary
appealing for the
manner
state in this
selected.
matter? Mr. Patnaik, that simply we are disposing this petition with director to this representation at annexure 5.
Yes,
Up to annexure 5. That is in Orissa, but it says that the present place is not suitable for the public interest. So let the appropriate authority decide it.
yes, yes.
To whom you
Yes,
have
my
made the representation.
Yes.
Annexure 5 series, my lord.
To whom you have made the this annexure 5 representation.
Annexure 5, my lord, collector.
Address to whom?
Address to collector, my lord,
Collector,
annexure
my
All
5.
right, the collector is a separate person, so I direct. Until then, don't take any decision regarding construction.
My lord, that part I don't know whether there is.
No further proceeds means I will
My lord,
give
this was-
time for 30 days.
This was that annexure 1 was dated 5/4/23.
All
So
right, what is happening, we don't know, but because
We
of
don't
the
know.
selection of land.
for construction, so I don't know about
All right,
the.
it's a direction and take it.
Let them take a decision on annexure 5, my lord.
Right. You are Mr. Vishwanath Daloi,
Manoranjan Das.
or Mr. Amar Das from council appearing for the petitioner. The petitioners are the villages of village Mulokondia under Kotuk district. The grievances enumerated in this petition is that the location for construction of this building of subcenter has been chosen at a place which will not serve the public purpose at all. So accordingly, they have asked this court to coerce this communication dated 5/4/2023 under annexure 1 to this petition, whereby land for construction has been shown to have identified stuff. Mr. Das, council has submitted that being agreed by the said action, the petitioners and other villages made a representation to the collector of Kotak, district Kotak, for reconsidering the said decision. But no consideration upon the said representation has been made as yet. So we dispose of this writ petition by directing the collector, Kotak district, to take note of the grievances of the petitioners and consider the representation within a period of 30 days from today, from the date of receipt of a copy of this order. Stop. Till then, the annexure 1. Till then, the decision as reflected in the annexure 1 may not be acted upon, if not already acted upon. All right. A copy of
Obliged.
this order be supplied to Mr. J.P. Patnaik, government advocate appearing for the opposite parties here in this
My
petition.
lord, extremely sorry, my lord, the previous item, item 5.
Ah.
I was just late. The previous item.
We have dismissed your petition, Mr. Is it dismissed? Last occasion also you are not
No,
there.
I was just late by 1 minute.
All right, you just wait, we recall this order, scrap that order. All right, wait,
My
we'll call.
Item 7.
Should depute some of your friends to mention that you'll be late. Yeah.
Wait, please. And item number 7, I'm for the petitioner here. And this is a work related to Sundargarh municipality. It's a tender floated by the Sundargarh municipality with regard to sanitation work. I was successful in the earlier bid. I executed the agreement and I'm continuing as such. The difficulty is, my terms of the agreement expired in February 2023. That is for 3 years. There is a renewal clause in the agreement. After the expiry of, immediately before the expiry of my period, I was called by the municipality to, with her instruction, you continue with the work. We will going to extend your agreement in terms of that clause. So you go on with the work. At that point of time, an amount of 2 crores, some odd amount was due by the municipality, which is as on date due. I made a request that you clear the erstwhile due, execute a fresh agreement. Then only I will be able to invest further for the 1 year, because I have to invest in vehicle and manpower as well.
Yes.
So they assured me, and there is a letter to that effect, that within 3 days we are going to execute the agreement. So I acted upon it. I invested money and I'm continuing as such. Thereafter, I made another representation wherein they called me and said that within next 10 days we are going to execute an agreement. You continue. This way, 6 months out of the one next year has already elapsed, and as on date I am working. But there is no agreement executed. My dues are pending. When I approached the authority with a representation,
Just come to the annexure 3.
Mal.
It is very categorical up to 31st of May.
Yes, or
We are in the month of July now.
no, if your lordship sees 24 page, annexure 3, it
Yes.
says is hereby extended on existing terms and the condition up to 31st May or till finalization of the further tender process, whichever is earlier, my lord. 31st May, my lord, has elapsed.
You forget about this further tender process.
My lord.
And whichever is earlier. Means
My-
what the 31st May 2023 is the ultimate date.
Is the earlier, my lord. My lord, 31st, your lordship will kindly see page 23 for a moment. That is annexure 2. That was the first representation. Pursuant to that,
No, we are not concerned. It is a
Mal-
highly contractual matters. You must
Mal-
also recognize our limit.
absolutely.
So where the contractual
Powder.
matters are concerned,
Mal-
if there is an arbitrariness, that will interfere. Otherwise not in such a matter.
Mal-
Whether someone will renew your contract or not, completely within the executive discretion and
Mal-
consideration.
My humble submission is, my lord,
Yes,
pursuant to the 31st May 2023, which is the earlier date as per annexure 3,
yes.
they are still continuing with me without executing an agreement. And in the process, my lord, when I wrote a representation at annexure 4,
Where is your difficulty?
my lord, my difficulty is, my lord,
Yes.
now when I wrote annexure 4 to the municipal authorities that you
Yes.
act as per your promise or pay me the amount
Yes.
and allow me to, they floated another tender for a period of 1 year. That is the subject matter of dispute. Within that 1 year period, I have already worked 6 months and I've invested my manpower and the machines and everything, basing upon the assurance given by wide annexure 2 and 3. Now, my lord, they have floated another
But
tender.
thereafter annexure 3 came. It is the latest communication.
Yes, pursuant to annexure 3, annexure 4 is there. If your lordship
Yes.
may kindly see.
Come to the annexure 4.
My lord, page 25, if your lordship sees.
Yes.
You mean to say, though they have issued letters by annexure 2 and 3, they have not executed any agreement?
Any agreement, and I'm continuing as such without any agreement after the expiry, basing upon their assurance and have invested money.
It is not a question of the assurance. Annexure 3 is by all means is an extension of that agreement.
My lord.
Though it is unilateral and you have accepted.
Or till finalization of.
This is the 31st of
whichever
May is the
Mal-
cutoff date,
Mal-
right? It is the watershed.
Yes, ma'am.
And beyond that, they say that if the new tender process is there till settlement, whichever is earlier means 31st May.
31st May,
Land Council just work. Because where is your danger? That you have worked for 6 months, you have
Well,
invested money.
my lord, in
No,
short,
beyond 31st of May, if you worked, you have worked at your risk.
my lord,
But they have, since they have realized your services, Section 70 of the Indian Contract Act will protect your interest. Right? They cannot deny that they have not. So you will be paid.
My lord, I will be, my lord. My
Ah.
only submission is, my lord, before floating the new tender, which is the subject matter of dispute, my lord.
How the court can say that don't go for tender?
No, my lord, absolutely not, my lord. Absolutely.
Yes.
I'm just relying on a short principle, which is backed up by a decision of the Honorable Court, my lord, on the
Yes.
Honorable Apex Court, which says, I've got a copy, my lord, which says that once an assurance in the form of any writing is made by the competent authority and they have acted upon it, if they change from that or deviate from that action, I have a right to be heard, my lord. The
What-
reason,
What is the change?
my lord, the change is, my lord, they assured me I'm continuing as such.
No, just like appreciate that fact that annexes 2 and 3
My lord.
is an anterior communications.
My lord.
And then annexure 3 has come.
My lord.
And annexure 3 has eclipsed whatever the promise they have made to you
My lord.
in annexure 2 and 3.
My lord.
So you cannot just say that they are stopped to take any decision.
My lord.
They have made it very categorical by annexure 3
My lord.
that it is 31st of May 2023
My lord.
or the tender, which will be the earlier. Earlier is 31st. of May.
31st May, my lord. But my humble submission, I bow down to your lordship.
But you're still continuing.
Yes,
That
is.
means it will be till the tender.
Well, till that, and that is my entire difficulty. 31st, I acted upon their assurance till 31st May, my lord. I
Yes.
had a right till 31st May because of the communication at annexure 3.
Yes.
But my humble submission is by way of conduct in allowing me to proceed further for next 3 months, which is still continuing, my lord.
Yes.
My lord, my humble submission is annexure 3, but may not be considered, and my action is to be considered. I made a representation without taking a decision on my representation. I'm continuing, and I have wrote categorically that I am investing money regularly. So you hear me before you.
I tell you, just read section 70
My
of the
lord, I'm
Indian
protected.
Contract.
I'm protected.
You are protected.
Protected. So far as money is concerned, my lord, I'm protected.
Protected. The later part court doesn't have any power to interfere
But
with.
only if I may make a submission, my lord.
Are you not participating in the tender process?
No, my lord.
Okay.
I'm not participating on the ground of this conduct, my lord. This has not come for the
So
first
we'll
time.
go
You are
to
taking the decisions at your peril. How the court can save you?
My lord, my
You have
humble,
already decided. You have also presupposed the court's action that
My-
the court will go in my favor.
my lord,
This is not a case of this promissory estoppel, Mr. Counsel.
my lord.
Because of this annexure 3.
My lord.
You are trying to just showing to us the Supreme Court decision based on the promissory estoppel. The principles are well enunciated by various pronouncements. Then you have to show that you have altered on their basis of the promise. But their promise has been withdrawn by you of this annexure 3.
Therefore, thereafter the action, and it says that if there is,
This is an unilateral representation.
my lord,
That doesn't create, or even if you write that you have talked to me, unless they agree, they admit this, there is no question of that.
my humble submission is if they take a decision on annexure 4,
Huh.
they take a decision because as on date, though the tender has been floated, as on date, nothing has commenced. So
All
if,
right, we'll ask them to take a decision on your annexure 4 before the tender is settled.
My-
That much we can do.
my lord,
All right. Who is appearing for the state? Mr. Mudali, you are not passing any effective order. Just
municip-
wait.
Only your lordship, before my lord, direct for consideration of annexure 4, your lordship kindly see the subject in annexure 4.
We
That
have
is not
seen
relating to any extension of
request
the
to release
contract.
of pending bills.
No, my lord,
Yes,
if-
not,
my lord,
not
page
relating
30
to extension
But
of
you
contract.
read the
And if it is a dispute relating to pending bills,
Yeah.
so it can be
No, this
adjudicated.
penultimate para you read. The secondly, you asked for a fresh agreement. That paragraph you read.
In this
Just
matter,
the paragraph above the final paragraph.
yes, secondly, you ask for a fresh agreement for extended period of contract that is up to 31st May 2023 or till finalization of further tender process, whichever is earlier. In this matter, our director attended your office, but unfortunately could not be possible. Kindly intimate us a particular date on which a fresh agreement will be. So that will be for the period till 31st of May,
No.
whichever
This
comes
is
earlier.
beyond 31st because annexure 3 is an extension of the agreement.
Yes, that is whichever is earlier. So 31st May comes first.
No, that I pointed out.
Yes.
Now only what you are doing this. But who is representing Sundargarh municipality?
Coming for the
Mr.
first-
Maharana, disposal of annexure 4, will it help you?
The ultimate prayer is for release of pending bills.
No, my lord, in fact,
Ultimate
so
prayer
far
is-
as release of pending bill is concerned, your lordship had pointed out, my lord, I will be
No,
protected.
no,
and
we are asking annexure 4, is it going to help you if we ask for its disposal?
my lord, help me in a way that they have to take a decision if because annexure 3, even
get
though they
one
have
more
written
contract.
31st May, my lord, towards the bottom of that letter, they said you are hereby requested to continue the sanitation work as per previous terms and condition and execute a fresh agreement within 10 days of the receipt of the letter.
No, that's annexure 3 has come later on. So don't read these 2 and 3 now. They are stale now. So we just, because the municipality is not represented by anyone, it's very difficult without hearing pass an order.
Because ultimate prayer is to release the bills.
No,
Last
That was the last two, this penultimate paragraph I have pointed out, this says on the basis of their prayer, this fresh agreement be executed. All right, we are just.
Period has gone.
But if your lordships directs the Sundargarh municipality, my lord, to appear because state government
You
no-
represent Sundargarh, take the interest, nothing, we are not passing any effective order, only for consideration of the representation at annexure 4. All right.
My lord, may I make a humble submission, my lord? Let Sundargarh municipality be, my lord, notice in this matter and take a decision there in their presence, my lord.
I was just expecting this submission from you.
Right.
But please don't do this because we are taking a risk. Without notice, we are directing someone to this, because we are not passing any direct adverse order against this party. And Mr. L.K. Maharanal and Council appearing to the petition. By means of this writ petition, the petitioner has challenged the tender/bid reference number SNGN-02/2023/24 dated 17/6/2023 under annexure 6 to this petition. And also urge this court for directing the opposite parties number 1 and 2 to execute a fresh agreement in favor of the petitioner in terms of the letter dated annexure 2 and 3 in respect of the work involving the tender call notice. Stop. It has been further urged that the action of the opposite parties number 1 and 2 issuing the tender bid reference dated 17/6/2023 under annexure 6 to declare this as invalid and as consequence thereupon be quashed. Even the petitioner has urged this court to direct the opposite parties number 2 to execute the fresh agreement in terms of the letters dated 2 and 3. In terms of the letters under annexures 2 and 3. Stop. Mr. Maharana Learned Council has quite strenuously submitted before us that annexures 2 and 3. Now, letters at annexures 2 and 3 clearly extend the promise to for continuation with the sanitary works as per the previous terms and conditions and for execution of a fresh agreement within 2 days. But such promise has not been honored by the opposite parties number 1 and 2. Stop. Mr. Maharana Learned Council has also referred to the representation made by the petitioner on 19/5/2023 to the executive officer, Sundargarh Municipality, under annexure 4, whereby the petitioner has urged to execute a fresh agreement on the date as it be communicated by the opposite parties number 1 and 2. But the main thrust of this said representation is for release of the pending bills in order to tide over their financial difficulties. However, in this petition, there is no prayer relating to the release of the bills. The prayer is made in this writ petition is confined to the execution of the fresh agreement by extending the term. So, we have come across the letter dated 24/2023, Annexure 3 to this writ petition, where the executive officer Chandragarh municipality has clearly stated that the agreement / contract executed on 22/2/2022 is extended on existing terms and condition up to 31st May 2023 or till finalization of further tender process, whichever is earlier. From the very language, it's unambiguous. The final date of the agreement to come to an end is 31st May 2023. So Mr. Maharana Learned Council has submitted that even after 31st May 2023, the petitioner is continuing with the sanitation work by investing his manpower and money. Stop. Thus, the opposite parties, number 1 and 2 in particular, have responsibility to execute as a fresh tender in favor of the petitioners. This is the process for new tender shall be interfered with by this court. While contra, Mr. P.K. Mudoli, Learned Counsel, Learned Additional Government Advocate, appearing for the opposite parties, number 3, has submitted that the petitioner doesn't have any right to challenge the subsequent fresh tender. In his master, he doesn't have any vested right to do the sanitation work alone. Stop. The opposite parties, number 1 and 2, have right to select the best performing persons having resources after the earlier contract comes to an end. So there's no illegality. And the grounds taken by the petitioner doesn't confirm him any right to challenge the subsequent tender process. So we have given our anxious consideration and we are of the view that the letter number 820 dated 25/2/2023, Annexure 2 to the writ petition, and the letter, before that letter dated 22/1, this 22/2022, Annexure 1 to under Annexure 1 to the writ petition, and the letter number 80 dated 25/2 is the Annexure 2 to the writ petition. Sorry, Annexure 2 to the writ petition doesn't create any indivisible right to in favor of the petitioner to continue the agreement in view of the subsequent communication. That is the letter dated 24/2023 under Annexure 3 to the writ petition, which has ambiguously spelled out that the agreement that has been extended will continue till 31/5/2023, or when the tender will be decided and whichever is earlier. Stop. As there is no dispute that the no tender has been decided as here, but the process is going on. Stop. We are to accept 31/5/2023 as the date when the agreement / contract has come to an end. Stop. If the petitioner has been continuing the contract by investment money, that should give a fresh cause to the petitioner for demanding the payment against the service that the opposite parties number 1 and 2 has realized from him. Not beyond that I'll observe anything. However, we think the opposite parties number 1 and 2 shall respond to the representation dated 19/5/2023 and issue 4 to the this petition. So accordingly, we direct the opposite parties number 1 and 2 to dispose of this representation dated 19/2023 under Annexure 4 to the writ petition within a period of 10 days from the date of submitting the order. Petition shall be communicated. Communicated about the disposal of the said representation. Stop. We would like to make it abundantly clear. Our above observation shall not in any manner prejudice the petitioner's claim in respect of his works. Stop. In terms of the above, this petition stands disposed of. A copy of this order is supplied to the learned counsel for the parties. So we request Mr. P.K. Madhuli, learned additional government advocate, to transmit a copy of this order to the executive officer, Sundargarh municipality, as early as possible.
Item 8.
Petitioner has filed this, yes, my lord, against inaction of the opposite party, my lord. Since the representation pending before him, 26/6/2022. That case is the petitioner is that, my lord. The land has been encroached by the opposite party number 4, the one school, my lord. This land is belongs to cremation ground. That's what this.
Already you have the defects in the petition.
Yeah, I have filed a representation. The only your lordship.
My lord, representation will not do. My lord, he's in the petition, he's alleging that during settlement operation, that has been changed.
Yes, ma'am.
But in the representation, it is in a consolidation proceeding.
No, I have.
No, I point out. I'll point out. So which proceeding it has changed? Those their quasi judicial bodies, and they can go there in appeal or revision, and the case may be.
Yes, well,
Nothing.
The collector cannot do anything because the collector.
I have also intimated to concern Tahsildar.
No, you go there where it is.
Your lordship only direct to consider whether I am
No. This matter, this is a statutory order. How can I say the consideration?
The separate thing, only my
Sorry,
representation
learned
pending.
counsel,
26
we are all dealing with
2020.
the laws. Ordinary citizen may not know.
Yes,
Suppose in a proceeding, some order is passed, you remedy before either the appellate or the revisional authority.
yes,
If there is no remedy, only then you come before us under Article 227 or 226.
so my only to consider this application pending before the
that
opposite
will be
panel.
just inviting the
2 and 3.
indiscipline in the
By
statutory
taking that
process.
that
You will not do
opportunity,
that.
he is
You
going to
withdraw the
construction.
petition. Unless otherwise
playground
you
or-
make some adverse comment, you withdraw this petition.
It was changed to the school's playground. That is his allegation. Is
All right, you may have a genuine grievance,
Yes.
but the remedy is not here. Go to the statutory authority. Go to the statutory authority. File an application to the collector. Who is the appellate authority? I think collector.
Collector, same mood. I have already
No,
submitted.
not
documentation.
same body. This should
Application I
not
have
be.
already submitted. He has not considered.
No,
They have not both
there.
opposite partner 2 and 3. Collector and consult Tahsildar. They have only sitting with them matter since long. 26.
if it is Chokabandi, that is consolidation, it is the authority is consolidation commissioner.
Your lordship,
It is not the collector.
Your lordship.
They have not made them a party.
Direct to the concerned opposite area 6, which consult Tahsildar. He will be acted
cannot-
upon
No,
need full accordance with law.
interfere in the
Whether-
statutory process. Try to understand that we are not here to make anarchy, but you have to consolidate the judicial processes as laid down by the law. And this is the crux of the rule of law. If the court started behaving like this, this
So
will
your lordship
only
said,
invite
my
chaos
consider
in the
that I will
process
also
of law.
produce all the relevant documents there. Both
No,
for-
you may have certain anxiety, we appreciate, but we withdraw this petition, we give you the liberty to approach the statutory authority.
So your lordship,
We'll do that. Withdraw, first file a memo.
I will file him.
Just right now file, otherwise you will not, we are passing the order, otherwise you will not cite the order.
In the PILs, are you permitted to file without court fee and all that? Because You have
But I
not
wanna-
paid court fee of rupees 24. You have not paid.
Not 20, I have perhaps.
No, that is the defect which has been
Yes,
shown.
ma'am.
I
I
am
have
not
already,
aware.
perhaps I have paid only 20 rupees. I will pay in the course of that, I will pay.
All right,
Yeah.
paid. File the memo on these aspects
Yes, ma'am.
also.
Welfare fund.
Heard Mr. Kapila Charan Naik and counsel appearing for the petition. Mr. Naik has submitted that this is a public interest litigation. Oh, all right. Did that. Then under instruction, you would withdraw this petition to take the appropriate action at law before the authority. Stop. In this regard, he has filed a memorandum of secondly. So we do not find any impediment. And as such, the leave is granted as sought for. In the result, this petition stands dismissed and withdrawn. Stop. The petitioner will be at liberty to approach the appropriate authority. And this dismissal will not come in their way. Okay.
The provisions, I could not have straight away prayed for reading down the statutory provision.
Yes.
So I have filed an IA for amendment. It's a simple amendment. And I have inserted the necessary
Have you not filed it?
My lord?
Have you filed it?
Yes, my lord. It is in flag B. Copies have been sought. My lord, I have replaced the cause title page and also I have inserted the necessary prayer portion
Amendment is there. How does it change it?
at page 14 of the.
How can you do that?
My lord?
How can you do that when you have not allowed your amendment?
No, I have filed an IA. I
Oh,
have
you have filed an
praying
IA.
for
You don't say
praying
that
for
you have
amendment.
filed the consolidated petition already.
Yes, I prayed for the amendment. IA at flag B. You are
All
also.
right, who is appearing for the state, Mr. Kunti? I don't find they let them incorporate these things.
In all the
Mr. PC Chenchani, Learned Counsel appearing for the applicant. This is a 9265I, huh? This is an application for amending the writ petition for purpose of incorporating additional amendments and relief. Additional amendment. No, additional reliefs. And change in the cause title of the writ petition. Stop. The details of the amendment as proposed has been provided, have been provided in schedule of the amendment appended to this application. We have asked Mr. M.K. Kuntial, an additional government advocate. We do not find that if this amendment is allowed to be carried out, there will be any change in the character of the writ petition. Accordingly, we allow the writ petitioner, allow the applicant to amend the writ petition in terms of the schedule of amendment. So, the result, this application stand allowed. So the petitioner is directed to file the consolidated writ petition by the next date of the writ petition. After supplying a copy to Mr. Kuntial, an additional government advocate who is appearing for this opposite parties stuff in the writ petition. Release this matter on 29th of August 2023. Meanwhile, the petitioner shall file the consolidated writ petition in terms of our orders passed today in I number 9265 of 2023.
My lord, may
So
I
you-
submit, my lord?
Mr. You want to replace paragraph
Replace.
3 and 4 of the prayer?
Yes, that is what I have also.
No, you have not explained very clearly.
My lord.
You have stated that may be permitted to be amended. You should have asked for substitution. That's
Page one of the cost title.
So schedule, whatever they are.
I have
that is not clear. No,
page
they
one of the
permitted to
cost
be
title
amended
as well as in page 14 of the prayer portion has to be replaced, my lord. The whole writ petition may not be required to be.
It is up to you. He asked you to file a consolidated writ petition, you file it,
My lord.
but this is the rule. Then
My
you
lord.
have to follow that. You are supposed to get 15 days. We have given you more than that. By 29th, you file it. What about the other writ petition?
In all the writ petition, I have filed the I checking amendment.
The sign that change the name.
All the
thing will be
5
like that
petitions.
order, but I's are different. Check out.
It will come on, my lord.
29th of August.
Item 11.
Read your lordships.
File it much before that so that it can be incorporated.
No,
May I
they
please
will
your
file
lordships.
incorporated writ petition, whole writ petition, they will file up for incorporation.
That will be incorporated in the file. They have to replace and add the annexes after it.
They will do it.
Please your
He
lordships.
gives it on that.
Right,
day,
in
he
so
puts it
far
on
as
the
defect is concerned, in the last occasion, it was pointed out and I have updated in online. Again, when I show the defect on Friday list, my lord, I have filed a hard copy before the registry. That is only a page number 37 of my appeal, which was due to oversight. I could not able to scan it during COVID time, my lord. The fact remains are like this, my lord. There was a writ petition which was filed questioning the statutory obligation on the part of the statutory authority to discharge their duties in time. That writ petition was dismissed by this honorable court on the ground that once they have discharged, they have returned your money after 7 years, and then you have no grievance thereafter. But the fact are like this.
When have you filed this page 37?
Pardon me, lord.
When have you filed that page 37?
My lord, before this registry, my lord, I have a receipt on that. My lord, on Friday, my lord, I have been filed because I came to know on Friday, my lord, because online I did it, but it is not showing me online that there is a defect. But when I got the list, my lord, I came to know that there is a defect. It is showing in the list. So immediately I filed a hard copy on Friday, my lord.
All right, just we will be fixing another date because the stamp reporting has not been done. So
My lord.
after you just remove this defect, they will do it.
Very well.
Some other date will fix it. 11th of August, it will come again.
Very well.
You are Mr. Mahapatra?
Yes, ma'am.
Why it is shown you are appearing in person? You are appearing in person.
Yes, ma'am.
All right. Mr. M. Das Mahapatra. The petitioner in person has submitted that. He has already submitted the hard copy of the page number 37 in the registry.
May I request one thing, my lord? Lord, if your lordships give me 1 day time, I may comply today. It may taken up tomorrow, my lord.
Tomorrow is not possible. Tomorrow is not possible because we are already congested port. So
Very
it
well,
will
ma'am.
come on 11th of August. So you have filed it already?
Yes, ma'am.
All right.
I have filed on
Page
Friday.
37. So registry is directed to scrutinize. And if the page 37 has been filed, that shall be compiled with the this
At
petition.
least on
and
if
read
Friday, my lord, it can be accommodated, my
No,
lord.
it cannot be.
Very well. I leave it to your lords.
The memorandum of read appeal. Stop. It appears from the records that the stamp reporting has not been done. List is directed to complete the stamp reporting by 4th of August 2023. Stop. Already come on 11th of August. We'll hear you.
My lord, 11th August, my lord. Very well.
Item 12.
Yes.
In item 12 on last occasion, your lordship had directed me to submit the judgment.
You are challenging which order?
I'm telling the order of contempt petition. Contempt order, my lord. So regarding that maintainability, your lordship had directed me to
Come to this straight away. This order dated 17/8/2021. Order dated 17/8/2021.
Yes, ma'am.
There is another also annexure 220.
That is annexure 1, page 24.
Which one is challenging? One only.
One, man. Page 24.
Heard Mr. See this order. You have already filed a compliance before the learned single judge.
Yes, my lord. Why you have filed?
And he is
Because,
not satisfied his further direction.
yes, my lord. That's why we have.
All right. M.K. Kuntial and additional government advocate appearing for the appellant. By means of this intercourt appeal, the order dated 17/8/2021 is passed in contempt case CONTC number 3985 of 2021 by the learned single judge has been challenged. On reading the said order, we are of the view this appeal to be admitted for hearing. Issue notice returnable on 4th of September 2023. Steps for service. There is no delay, I believe.
90 days.
Oh, why don't you first say that there is a 90 days delay is there?
Sorry, my lord.
You should first say that the appeal is barred by limitation.
90 days. So there is a.
All right, just score out this order.
My lord.
Take down this now. This I number 2366 of 2021. Mr. Such and such, an additional government advocate for the applicant. This is an application under sections 5 of the Limitation Act for considering the delay of.
And that delay, my lord, during COVID period. So in fact, there is no delay.
No, they have shown because I don't know.
Yes, that COVID, that you'll also say that order is 17/8/2021. So COVID period covers up to 1st June 2022. This was filed on 10/12/2021. So it's not there is delay.
What is that judgment show us? What is the date? It is February or
that till Feb 28/2/2022, it covers 90 days. 28/2/2022.
Oh, you filed on
Yes,
10,
but this
12,
that is within my that is filed on
just in this
10/12/2020.
Just to restructure, Mr. M.K. Kuntial, an additional government advocate, has pointed out that the delay that occurred falls within the general waiver declared by the Honorable Supreme Court in Re-Contangian. Just, do you have the copy of the order? Do you have?
I'm giving that copy of the Honorable Apex Court.
Sometime in May, I think.
Page 4, you'll also can find paragraph 4.
In cognizance of extension of limitation.
4.
Order dated. Tenth January 2022. This is the order. Thereafter, another order is there.
No, that's the last order that covers 28/2/2022. So after 28/2/2022, 90 days. So that even if that I am not on that 22, so within that 20,
order dated 10/1/2022 has passed in a series of miscellaneous application. Of this miscellaneous application number 21 of 2022. In view of the direction of the Supreme Court, in view of the declaration of the general waiver on the ground of the pandemic, this appeal should be deemed to have been filed within time. So accordingly, this application stands disposed of. Then go to the review of the order passed today in I number 2366 of 2021. This appeal has been taken up for consideration. Heard Mr. Such and such earlier order now that is code out. Just repeat it. Step, issue notice, notice is made returnable on 4th September 2023. Steps for service of notice shall be taken by the appellant within 3 days from today by registered post with AD. Step, the records of contempt CONTCN number 3985 be placed with this appeal records. Stop. Do you have a further prayer?
If your lordship will call for that record, so there is no requirement of
All
stay.
right.
Contempt, secretary, so କଣ?
All right.
Well,
Item 13,
May I please?
You just give a photocopy of this. Yes.
This appeal has been filed by the state. In fact, I have filed two IAs. One IA at flag A, IA number 2457 of 21 for dispensing with filing of the certified copy for the time being. And the second IA at flag B, IA 2458 of 21, that is regarding condonation of delay of 707 days delay.
Why this prayer for dispensation?
We have not obtained the certified copy.
Why not? I am told it takes only 3 to 5 days for having a certified copy from the High Court.
I will file. You let me grant some time. I will file the certified copy.
Already filed. We are fixing the matter on 11th of
File-
August. In the meantime, we file the certified copy.
My lord,
Mr. P.K.
I have-
Muduli. No, nothing. You are I will not hear you now.
sorry.
Mr. P.K. Muduli, an additional government advocate, has prayed for some time for collecting the certified copy to remove the defects as identified by the registry. Prayer stands allowed. Let the matter be listed on 11th August 2023.
item 14,
Item 14, my lord, on behalf of Mr. Prafulla Kumar Rath, my lord, no instructions.
No instruction.
My lord.
File a memo.
Yes, my lord.
You are there on record.
No, my lord, no.
Someone on record will sign the memo.
Yes,
Already there's a lot of counsels are there.
yes, ma'am.
Stop. It has been stated by Mr. What is your good name?
C. Purohit, Chirag Purohit.
Mr. Chirag Purohit, Learned Counsel, appearing on instruction of Mr. A. Behera. We are reflecting the name of Mr. Behera. He is there working with the chamber of Mr. Roth now.
Yes, my lord.
Mr. A. Behera. You will get the signature of Mr. Behera on
Yes, yes, ma'am.
that. There's no instruction from the appellant. Says there is no in a position to make any submission before this court. In view of the above statement and the memorandum in this regard that has been filed in the proceeding, we dismiss this appeal for non-prosecution. Yes. You file this memorandum.
item 15,
Ma'am, item 15, there is an IA for condonation of delay, flag A, my lord.
Already said, let us see.
Only
notice.
14 days, my lord.
13 days. 13 days, according to the stamp reporter.
My lord,
According to the stamp reporter, it is 13 days.
13 days.
Heard Mr. G.S. Sethi, Learned Counsel, appearing for the applicant. This is I number 3181. So this is an application for condoning the delay. So according to the stamp reporting, according to the stamp reporter, the delay is of 13 days in filing the intercourt appeal against the order dated 17/8/2022 as passed in WPC OSC number 4559 of 2016 by the learned single judge. Issue notice as to why this aforementioned delay shall not be condoned or any other orders, and orders as appropriate in the circumstances shall not be passed. Notice is made returnable on 29th of August 2023. Steps for service of notice on the opposite party. No, since you can accept notice for all. Right? Since Mr. So we can condone the delay of 13 days. Why you are passing the order?
OP1 has their separate,
Huh?
the respondent number 1 has the separate counsel.
And
Okay.
she has also
Since
entered
Mr.
her
All
application.
right, since
Can
Mr.
appear for
P.K.
respondent
Mudali,
number.
learned additional government advocate, APS, and who has notice for the opposite party number 2, no formal notice in respect of the said opposite party is called for. However, the applicant shall take steps for service of notice on the opposite party number 1 within 3 days from today by registered post with AD.
Madam, on behalf of OP number 1, she has also entered her own appearance. I will serve a copy on her, madam. Miss Sumitra Mahant.
Mr.
Miss Sumitra Mahant. She has entered her
You have served the IA copy on her. Have you served the condonation of delay petition on her?
I will serve, madam.
Will serve.
It has been stated that for the opposite party number 1, MS Sumitra Mohanty and counsel has entered in the appearance.
Pardon, my lord. On 4/4/2023, the notice has been issued, my lord.
All right. So they have appeared, the person just score out this order. The problem is that this is
So what do we do?
a writ appeal.
Sorry, writ appeal.
What is there? There is a notice on the limitation. Find out from this order. 4/4/2023.
Office note says notice on admission issued to R1 to R4.
I will serve an IA to my learned senior and also.
Notice has to be issued. No, there is no notice on the limitation application. It is straight away the notice on the
Appeal, my lord.
appeal. Just all right. It has been stated. Just to score out this step. It has been stated that MS Sumitra Mohanty, learned counsel, has appeared for the opposite party number 1, and as such, a copy of this application for condonation of delay be served on her, and that will be treated as sufficient service.
I will serve mine.
All right, I'm recording your name. Do you have any objection?
Your Lordship.
13 days delay. Delay is of 13 days.
Your Lordship, counter has already been filed in it petition. I am appearing for first time in this writ
The
appeal.
problem is that when the order dated 4/4/2023 was passed, no notice on the limitation was
Your
issued.
Lordship. Your Lordship.
So if you do not have the objection for 13 days, we can condone the delay.
Without
can-
recording.
Your Lordship.
All right,
Yes,
just go this order right again. Heard stop with the issue notice. Up to this you keep. Stop. Since Mr. MS Sumitra Mohanty, learned counsel, appearing for the opposite party number 1, and Mr. P.K. Mudali, an additional government advocate, appearing for the opposite party number 2, has submitted that they will not oppose the prayer for condoning the delay of 13 days in filing the said intercourt appeal. So as such, we condone the delay, and the result, this application stands allowed and disposed of. Now, are you prepared to hear this for making submission on the merit of the appeal, or some other day?
On some other.
Where from? Some voice is coming.
That has been disposed of. That has been
So you
disposed.
just give me an agreed date. I will fix the appeal for now consideration.
Yes.
In fact, my lord, may kindly see the impugned order at
Infectious.
page 37. Well, on the basis of
No, are you ready for hearing the matter today?
1000.
Otherwise, we'll fix another date. In that case, we fix the matter on 29th of August. It's okay. 29th of August. Let the appeal, this main appeal, WA. Let the appeal be listed on 29th August 2023 for consideration and merit. Mr. G.R. Sethi and counsel has appeared for the appellate and Ms. S. Mohanty, Sumitra Mohanty and counsel has appeared for the opposite, these respondent number 1. Where is Mr. P.K. Mudali and counsel has appeared for the respondent number 2. All right. Come on 29th of August.
Item 16.
16 also my same prayer, only 14 days delay, my lord.
Whether the parties are here before us.
Here is a private party.
Private party, my lord, OP4, respondent 4. Earlier also notice has been issued on 4/4/23, my lord.
Notice is not sufficient as per the report.
As per the noting on respondent 4, my lord.
Problem is this, the notice has been also this issued in the appeal. But there is no step on the delay, 13 days. So you have to issue notice in 3196 of 2022. Heard Mr. Sajjan Sethi, G.S. Sethi and counsel appearing for the applicant. There is an application for the continuing the delay, which according to the stamp reporter is 13 days in filing the intercourt appeal against the judgment, against the order dated 17/8/2023, passed in WPC OSC number 4003 of 2016. So issue notice the same way, returnable on the same date. Sorry, issue notice since Mr. Mudali, are you there also?
1 to 3.
Mudali, learned additional government advocate, appears and waives notice for opposite parties number 1 and 2. No formal notice is called for. Stop. However, the applicant shall take steps for service of notice on the opposite parties number 3 and 4 by registered post with AD within 3 days from today. Notice is made returnable on 29th August 2023. So you take step on 3 and 4.
Item 17.
Certified copy has been filed on 28th and copy has been served to the opposite side.
That was the only objection against you. That was the only objection against you.
Actually, I've got proof of he has filed 28th. It may not be have come to the record.
Yes, come to the record already. My section officer told that already record tag in the record.
Already, now they have cleared it.
Yes.
So the they say they have filed it. When do you have the received copy of the filing?
Yes.
Just show us. Show us. Then bring that receipt. Mr. K.K. Patel and counsel appearing for the appellant has submitted that the certified copy of the impugned order has been filed on 28/7/2023. Stop. He has also placed the receipt number 64589/2023. Stop. We accept the statement of Mr. Patel and counsel and hold that the removed stands removed, the defect stands removed. You return it. Have you received this memorandum of appeal, Mr. Kuntia? Have you received the memorandum of appeal?
Yes. Yes, ma'am.
14 days that has been.
What about the delay?
Delay has been condoned.
Last order, by last order, right? Yes, now you make for submission on appeal.
Correct, my lord. This is an appeal against the Honorable Single Judge, order dated 17th. August 2022. In fact, my lord, the earlier it was also adjudicated, page 33. This is the page 31.
Just Mr. Patel, that we dispose of this another application you filed for dispensation of the certified copy.
Second, I filed a miscase for dispensation of the certified copy. IA number 3018 of 2022, madam.
30.
3200.
Which item?
How many counsels appearing in this case? All of you appearing for the appellant, all three of you?
No.
In second item, madam, second case, read appeal number 1237 of 22.
Connected matter.
Connected matter.
We are there in the first matter.
We are on the WA number 1311. When you turn in, come stand up, okay? In view of the certified copy of the impugned order dated, in view of filing of the certified copy of the impugned order dated 17/8/2022, this petition stands disposed of as infractuous. Yes, now come to the appeal.
Yes, my lord. My lord, as I have framed the question of law, whether this honorable court can issue direction to the state government to fill up the vacancies available from out of the panel maintained by Committee of Chief Engineers in view of observation made by the Honorable Supreme Court in Anurag's Sharma versus State of Himachal. I'll take, your lordship, this is the Anurag judgment.
Who is appearing to the state, Mr. Santhia? We'll take up the matter on merit, we'll dispose of. This is a very simple issue they have raised in the appeal. Is which paragraph?
Page 56, my lord, paragraph 36. Lordship got it?
Yes.
It is now a settled proposition of law that a candidate has a right to be considered in the light of the existing rules, which implies that rule in force, as on date of consideration takes place, the right to be considered for promotion occurs on the date of consideration of the eligible candidates. So I stop here. There was vacancies. There was a conscious decision and gazette notification that existing vacancies will be filled from the panel. Now you see 3. The government is entitled to take a conscious policy decision not to fill up the vacancies arising prior to the amendment of rules, which is not in the present case. Now 5. When there is no statutory duty cast upon the state to consider appointments to vacancies that existed prior to the amendment, the state cannot be directed to consider the cases. Whereas in my case, if you also see page 85 of the appeal.
Is a gazette notification?
That is a notification of 5th October 2013.
Yes.
It says, page 86, I'll take my word. Now, therefore, in exercise of powers conferred by Rule 19 of the State, Orissa Diploma Engineering Service Rules 2012, and in exigency of public interest, government, after careful consideration, do hereby relax the provisions of aforesaid rules till 31st March 2014, and as such, all appointments to the existing vacancies of junior engineers shall be made as were being made prior to the commencement of these rules from out of the panel maintained by the Committee of Chief Engineers, Engineering Chief Orissa. They drag it up to 2019. So I am also arguing that we were discriminated And
How? Tell us. This is a very interesting point. Because this government policy
yes,
will be considered by this court till the date of 5th of October 2013. Because government has declared that policy that the vacancies as exist on that day issuance of this notice, that will be considered and filled out by the junior engineers without following the new amended rules. That is the crux of this notification. So after that date, whether any claim can be sustained by the court.
if vacancy would have arisen after that date, this court will not consider. But the vacancies which existed prior to 31st March 2014.
Prior to 5th of October 2013, you are eligible for consideration.
Yes.
Okay. Mr. Who is appearing, Mr. Kunthia?
Yes, ma'am.
It is your own policy. You have said we will do that. We will not actually in a way implement the subsequent amendment. You will not do that. It is keeping it aside. And a new method has been evolved. The rule is not being implemented. You say that we'll go by the rule because we immediately need appointments. And the person was also eligible to be considered against those vacancies, but you have not considered him. And that is perhaps the case of the petitioner. How can you do that?
You can find it from paragraph 15 of that judgment.
Paragraph
15. Or your lordship can fix a short date so that I will come with a short note. I can convince you. Your lordship,
Paragraph 15.
15, 1-5, madam. Page 71.
Yes. But you read again this Annexure 7. Later part. Now, therefore, in exercise. What is the government's decision has been
Paragraph
notified.
15 and 16 is the reply, madam.
No, I'm not reply. I'm coming on the record first, and then we'll go to the reply.
Yes.
Sometimes records will just catapult us in a position that we do not require to even amendments.
Yes, yes.
Just come to that last paragraph, existence interest. Relax the provision of the effort till 31st March 2014. As such, the existing vacancies of the junior engineers shall be made as were being made prior to the commencement of the. So they say that all existing vacancies. Now you later on, you take out some 200 and odd vacancies out of the entire strength. And that is not publicly notified. This stand you have taken in your reply in the court.
Yes.
Show us any document that the position has been
Yes,
changed
I'll
by the
produce,
government.
I'll produce all the documents.
All right, produce it.
Well,
11th August.
11th, some more
time.
Well, 11th, I'm in difficulties last week of August.
All right.
Because I have to come from Delhi.
No, all right. Then make it on the 4th of September is all right?
4th of
September.
Yeah, 4th of September will be fine.
All right. So we are admitting this matter.
Madam.
Heard Mr. K.K. Patel, learned counsel, appearing for the appellant by means of this intercourt appeal. The judgment dated 17/8/2022. Delivered in which case, in which your case is? Which WP is your case?
My
No, no, first case.
first case,
appeal.
Manas Kumar Jaina.
No, Manas Kumar Jena, I cannot find out this. There is a cost title already. You are Manas Kumar Jena's case.
Yes. 1311 of 2022.
What is the case number of the Manas Kumar Jena? It is not
It is
there.
also, you can find it, he has mentioned 2645 of 2014, but it does not appear in that list.
No, this is certified copy. His name is there.
Writ appeal is 1311 of 2022.
2645 of 2014 arising out of 2645 of 2000. You also can find it from its court title.
Cost title is a little.
2645 of 2014, but it has been filed by Santosh Kumar Mandal and others.
That is why. But the appellant is
By
the Manas
which number?
Kumar
Yeah,
Jena.
there are batch of matters. It is
No, batch you cannot challenge it.
read number.
Yes.
Yes, I'm.
It's not there.
It is in the judgment. It is here, madam.
What is your writ number?
Yeah, I'm giving. Oh, what a- Manas Kumar Jaina. Read number. From the single bench.
There is-
Annexure 5. Annexure 5.
Ah.
See the number of number.
What is the number of the Manas Kumar Jena? That is why I'm asking here.
1048 2645.
Read number.
Whether in this order your case was there?
Kicho. First para.
In this
I
batch,
think
whether your
1048
case-
of 2014.
Yes, where is it? Where is it?
Page 8 of the appeal, it has been stated.
is 8. But in the certified copy that you have produced, your case
Not
number
there.
is not there.
Batch of case.
No, batch of cases, but the
But your writ
certified copy
number.
should have been obtained in that case. No? 1048 2645.
All right, passed in WPC OSC 2645 of 2014. You are also that paragraph also you have mentioned two names, two writ petition. There also you have mentioned two writ petitions. Check up on.
I'll communicate to the court master. Yes, it is
78.
1048 of 2017.
Page
It is
58.
there. Manas Kumar Jaina, that is OA number 1048 of 2017.
Page 58, your lordship can find it, that number is there. But it's a,
One number is only there.
but that is of 2017. Lordship can find it.
Correct.
No, that is why you just check up and give the number.
I'll check and
No, do you
give-
have a certified copy, Xerox copy of your certified copy? Let us see.
but I'll check out and give it to the
No,
master.
must have obtained in respect of some other petitioner.
I think there are several batches of petitions.
1048.
Don't do this.
Already you take time, just hand over the speed.
Yes, ma'am.
Yes, we challenge by the. He'll give the number. Reduce the
Your rate number is
order.
1048.
So when the parties are already in appearance, then the matter be listed on 4th of September 2023.
Yes, my lord, it is at page 58, 1048 of 2017.
1048 of 2014.
17.
But what is your case number?
That is the case number.
What has come here?
Shruti Samal and others. So
you-
Manas
you-
Jena is in this writ petition.
In paragraph 1, he has
Man-
mentioned 2014.
that is only shows the Shruti Samal is a single writ petition.
Actually, a lot of others were also there.
Now you are saying, but it
Yes,
doesn't show.
The court has not, and others has
Do you have a copy of the writ petition with you?
copy of writ petition.
My lord, in this
All right,
batch
let
of
us-
judgment, batch of cases, hearing one day, my
I-
lord.
We have heard, understood the number.
I'll
was-
clarify, my lord. I'll
Understood.
give it to the court master, read a number and read petition also.
You already passed your note.
The read petition, my lord, WC OSC 1047 1048. 1048 is 2017 is our case, Manas Kumar Jena. 1048 2017.
1048. Where is the
WPC OSC.
Page 58, my lord. Single, honorable
All right,
single
that
judge
is-
order.
that is- Check up. All right, we'll check up.
Yes, my lord.
What was the next item?
The next item, I filed a IF for dispensing with the certified copy, my lord. This matter also be taken up on that day, my lord.
Yes,
Delay.
there is a delay.
You file a petition.
I number 3018 of 22, man.
In your case, there is a delay of 125 days.
My lord.
Oh,
17 seconds.
second one.
So there is no delay.
No, not.
No delay. All right. And I checked on the website, this 10 of 2017 was Manas Kumar Jena.
104.
Eight. So this is the wrong one they have given. 1048 of 2017. Disposal date is 17/8/2022.
All right, only the dispensation petition is there in I number 3018 of 2022. Heard Mr. You are Mr. Jayanto Kumar Ratho.
No,
Mr. Amit Kumar Shah, my lord.
Ekesa.
My lord.
Ekesa and counsel appearing for the applicant. This is an application for dispensing the filing of the certified copy of the impugned order. Stop. It has been stated that this impugned order could not be collected in the period of limitation. But in just earlier the certified copy of this order has been filed by the appellant. Stop. In view of the above, we dispense with the filing of the certified copy in this appeal in the present in the connected appeal. Accordingly, this application stands allowed and disposed of. The WS same order passed, only the you give your WPC number.
WPC
order
number
passed,
2645, my lord.
we have taken up this
WPC
matter
was
for
2645 2014.
consideration.
Santosh Kumar murder and others. My lord. Our name is on.
Yes.
Niharanjan Sarkar. Niharanjan Sarkar.
This 17/8, WPC OAC number 2645 of 2014.
Man.
Already it will come on the same day.
And that 10, Mr. Patel, that 1048 of 2014 has been tagged by mistake or it is connected?
No, 17, my lord.
No. Cause title shows that 2014 has been tagged. So is it by mistake? It has no link with your case. That is what I'm asking. Then we'll ask.
No,
the-
linked with the case, same order. They are also challenging the same order.
All right, let it be there, common order.
Then that other one has to be tagged also. 1048 of 2017 has to be tagged.
It is already there.
That is 2014.
What is the number?
1048 of 2017.
Oh, all right. This is directed in the first case to detect the
No, they are
case.
saying that is also connected.
This is 1048 of 2014 is also connected matter
2000, yes,
or 17 is the connected?
17, 1048 of 2017 and his case, they are both connected.
Mr. Patel, we are saying that the office has tagged 1048 of 2014 with this petition. Does it have any connection with your writ appeal? Or we shall detag it and tag the correct case, which is of 2017?
He has mentioned
Mujhe-
one
mujhe-
zero- he has
Mr. Shah.
mentioned in the court title 1048 2014, for which your lordship may see that court title. In that court title, he has mentioned 1048 of 2014.
His mistake,
By
All right,
mistake.
let it be there like that only.
but the other one has to be brought.
And
That is
also
the
in
case.
first paragraph, he has challenged that
Yes, yes, mistake.
Rest is directed to place the records of
14.
WPC. No, okay.
The prostrator, he made a mistake and I will put in that.
It takes the case record of WPC OEC number 1048 of 2017. The other order will pass on the next date.
Well.
All right.
Item 18.
Item 18, ma- No,
Yes.
I have- There is an IA for condonation of delay, my lord, 19 days, my lord.
Against state. It is against state only.
Yes, against OPSC and as well as for the state.
So OPSC has a standing counsel.
I'm appearing for the OPSC. my lord.
Okay. Any objection?
I have no objection, my lord. 19 days delay is only there.
19 days delay. You have not filed the certified copy?
I'll file.
File it because.
I'll file.
All right, at the request of Mr. S.S. Settil and G.S. Settil and counsel appearing for the appellant, let the matter be listed on 27th, 28th August 2022. In the meanwhile, objection is raised by the registry shall be removed.
Item-
Okay, Mr. All right, let us record on the other day.
Yes.
All right.
Item 19.
Item 19,
Ah,
batch of matters.
use batch of
So for the
matter.
first matter, I am appearing for the respondent in a caveat. And there is a delay. So for the first matter is concerned, the other matters, I am also appearing in some of the cases. I'll give the numbers.
Mr. Rautre, give the list.
Sorry.
In which matter you are appearing?
I am appearing in WA number 1745, the first matter,
Please give us a list.
and 1138 of 2020. Oh, sorry, I'm giving the list. I'm giving the list. I'm giving the list. And so far the other matters are concerned, my
Because
documents
there
are
are
appearing.
45 matters. No, more than that. 17 matters, I think.
Yes. The matter, actually, the matter relates to the benefit, these are all municipal schools. The state government decided way back in 2004 to take over all the municipal schools along with the staffs. But while extending the benefit, they have in fact treated them to contractual from 2010. Though the resolution of the state government is, they will be treated to be government employee from the date when the school was taken over.
Where is that resolution?
So the Honorable Single Judge held that they must be treated to be the employees of the government from the date when they were taken over. That is the entire case.
So you are
And now they
appearing-
have filed the appeal.
You are appearing for the respondent. Yes. Where is the document in the resolution?
You'll also look to that document. They have not given. I am giving by memo.
No,
It will be
I have,
touched.
I have filed an additional affidavit. Lordship can find it.
You will file.
Additional affidavit
You have
that was
filed.
filed.
I think you have not served me a copy.
You have filed it. Have you filed it? You are not getting
Will
it.
your lordship look to this
On
government order?
24/7/2023, your lordship can find it from 24/7/2023, my additional affidavit.
Data copy. This is the crux of the matter. This is the resolution of the state government. This is on 28th April 2004. You also look to the subject, transfer of left out
20th April
primary
or
school.
20th February.
This is 28th February 2004. Let's get it.
Yes.
Just I'm reading two paragraphs. Transfer of left out primary school of 6 urban local bodies lower secondary and secondary school. We are from secondary schools of urban local bodies to the school and mass education department and declaring the teaching and non-teaching staff of these schools as government servant. Then you also kindly come to 7, paragraph 7. The non-regular teaching staff.
You are reading the earlier, you read paragraph?
7.
No, earlier, you read.
The non-regular teaching staff 220 in number and non-teaching staff 87 in number working in this school as on the date of taken over, that is 28/2/2004, are also declared as government servant. Also look to the judgment. Now this has been interpreted that though the original application was filed before the tribunal to treat them employee from the date they are appointed, that is long before 2004. The Honorable Single Judge directed that they will be treated to government servant from 2004, from the date of notification. That they have just state now has come forward to challenge.
It is your own resolution.
Yes, I'll come to that. So your Lordship said I have filed a application for condonation of delay. So there is a delay.
We are not getting that this affidavit in our record. Let's find out whether this any affidavit has been filed by the state. From the record, physical record, we find out.
Yeah, when was the affidavit filed?
I filed it affidavit on 24/7/2023.
Of course, you have not served me a copy.
No, copy has served.
Copy has been served.
Condolation.
Not in all other cases. Why I will serve copy to if notice has not. I'll serve only a copy to Mr. Rautrai, senior counsel, not to others.
Yeah, he is appearing in all the cases.
They have not appeared. I will serve.
A common judgment has been passed in a batch of cases. Same, similar, identical. Yes. In first case also there is a delay of 87 days.
Some cases delays more than 1 year, Milord.
More than 1 year.
Yes.
The first
What happened?
Accepting the first
In the first case, they are filed in after 87 days.
In the leading case, that there is a 87 days delay.
But when the question was raised that how one writ appeal will be maintainable against the common judge, even if common judgment of large number of cases, then in 2023 they are filed after expiry of 1 year.
After 1 year.
This is a bona fide mistake.
Yeah, this is not.
Now you come to on merit. The delay is condoned.
Yes, ma'am.
Don't insist on delay because you are admitting that.
We are ready, Milord, for disposal on merit, Milord. That will also serve the purpose.
Milord, date may be fixed, Milord.
These delay petitions allowed.
There is
You
a
have the
copy.
bona fide mistake.
Yeah, copy
Submitted
of
by the
the
appellants while filing the intercourse
Yes, sir. Jagdish Nair. Jagdish Nair.
So they filed the common appeal against the common judgment. So, such procedure is unknown to law, and this says later on. The other cases, the other appeals are filed, which is one of such appeal. And accordingly, it stands condemned. Only the 87, we find no reason to reject this petition for condemnation. There is an 87 days delay. All right.
I have served the copy of the additional affidavit.
To me,
I have already served.
All right.
Well, in this case, out of 45 cases, I am appearing in 22 matters.
You give the list.
I have also not received.
Appearance, regarding appearance, give the list.
I
Otherwise,
have
you
not
make
received a
mistake, more
copy.
mistake.
Copy in, not sought to.
No, just you make your submission.
Today, my lord. Yes.
We are taking up the appeal.
Your Lordship, a date may be fixed, Milord.
So far the admission is concerned, you cannot say a single line in this court that we will decide. You just say in view of this, what
You
Mr.
only-
Rautrai has pointed out in the paragraph 7 of the notification of the February this 2004.
Yes.
Is clearly the resolution.
I'll satisfy that. I'll satisfy that.
Then we'll decide when the next date will be fixed or not.
Yes, yes, ma'am.
Yes.
Your Lordship has seen that notification again. I will. Lordship may see my additional affidavit, and that
Where is the additional affidavit?
Mr. Das.
Where is the
Where is the
additional
additional
affidavit? I asked you
affidavit?
to find out the additional
A call for
affidavit.
it has been filed on.
24th July that was filed.
The case was in the list on 25th. Have you called or you will call?
No, I'm calling.
Huh?
I'm calling.
You will call.
Let's fix a date so that it will be.
Date may be. All right. What is there? Do you have additional copy?
I have given that.
Yes, yes, given a copy just now.
May I, yes, my lord,
Share as a copy, you'll return it.
my lord, to extract.
No copy to देंगे.
Computer वाला.
I'm giving well. Sit up. I'm giving that 2 copies.
Online file इतला हमको मिलेगा.
Do you dispute this document?
No, no, I am not. I will come to that. I will.
So just make your submission on the basis of this document.
Yes, yes, my lord. On the basis of that document, I will.
Make your submission.
Yes.
Yes.
दिलवा तुम दे दे. Oh, अच्छा अच्छा.
They have been regularized by the order dated 28/9/2016.
हम लोग जाएंगे एक्सपेरिमेंट करो जो मिस्टेक
डिस्टर्ब करना. Lordship has gone through that resolution dated 28th February 2004.
Now you come straight to the office order number
Yes, ma'am.
1439 dated 28/9/2016. I think that has created the problem.
Yes, yes, my lord. Yes, my lord.
Come to that.
Yes, my lord. That I am coming. That your lordship has seen that 28 to 2004, my lord. Thereafter, your lordship may see the next document that I have annexed it, page 15. My lord, these are non-regular staffs. So we made a provision on 11/12/2010. Plus, you can find it from page 15.
Whether did you file those documents before the learned single judge?
Sorry.
Did you file those documents before the learned single judge?
No.
Or except these documents, other documents are filed.
These documents that you are filing now by an additional
By an additional affidavit.
That was
You
not
have
filed.
those documents.
No, no. Except this document, other documents are there. Except this document, other documents are there.
No.
Let's see that 11/12. Why I am showing this document. Let's see that. Let's see that page 15. Man.
How this document is relevant for the present purpose?
Yes, my lord.
It is a creation of the new post of the contractual post in the UL.
Yes, my lord. They are non-regular staffs. We created a contractual post for them for their accommodation. LRC page 15.
Whatever you do, because come to this resolution.
Yes, my
that subsequently you say that we have created for them the contractual. That is your own administrative work. But the first resolution of the taking over of the schools is clearly very available. You have also annexed that document. This will come to this page 9.
Page clause 4.
Page 9.
Yes,
page 9 of your compilation.
My lord.
Yes.
Yes, ma'am. Page 9. That resolution, your lordship, clause 5. There are 2 categories of staffs who are those who are coming within the yardstick, they were taken over. Those who are surplus and non-regular staffs, LRC regulation of surplus staffs. The school and mass education have point out some surplus staff on the basis of their staffing pattern. These staffs are not surplus as per the requirement of because of school functioning or having higher density of population, school enroll more students than in rural areas. Of any school under school and mass education, these staffs will be observed on the basis of students as well as additional sections of this as per the methods followed by school and mass education. Then, my lord, 7. Non-regular service.
No, how does it help you? This regularization, this There shall not be surplus as per the requirement of the urban local bodies because the schools functioning in urban areas having higher density of the population.
Yes, these staffs will be observed on the basis of student strength as well as additional sections of these schools as per the method followed by the school and mass education department. Then the budget provision of housing or facilitating the staff salary of the teaching and non-teaching staff will be diverted to the budget school and mass education department. Then, my lord, your lordship, clause 7.
Yes.
The non-regular teaching staff 220 in number. Non-regular teaching staff in 220 in number and non-teaching staff 87 in number working this as on the date of taken over are also declared as government servant. For these non-regular teaching staff, there was no service condition, but so far as regular teaching staff, we have from the service condition to take over. So accordingly, in the subsequent decision 2010.
Wait. This is clear regarding the non-regular service.
Yes, ma'am.
It says the non-regular teaching staff, such as the number 220, and non-teaching staff 87 working in the schools as on the date of taken over I-28/2004 are also declared as government servants.
But yes, ma'am. We treated them government servant, but no service condition was framed for them. In 2010, we created the post for them. There was no post as per the standard staffing pattern. They are not coming within that staffing pattern. Accordingly, in 2010, we created a post for them.
When you are taking over a school,
because there is a school, there is a staffing pattern for the school that I have annexed that staffing pattern. You'll see that next page.
There is staffing pattern for the government school.
Yes, ma'am.
These are the different category of schools.
We have taken that school are taken over.
Just try to understand it.
Yes, ma'am.
Of taking over. You cannot throw out some persons in the course of the taking order. Those are just the alumni, the other working in the same school.
No, but we have not thrown them. Accordingly, we have taken over. So accordingly, for them, we have created because in a school year also the next page.
If we have created the post with with retrospective effect so that they can be absorbed there.
Yes, ma'am. That post creation is the 11/12/2010.
I have seen this is all are the contractual posts.
Yes, ma'am. I am coming to that. How that posts are converted to regular.
That in 2016. Again.
Yes, madam. Because when these posts are created, and we
so they are losing their regular service for 12 years.
Yes, madam. Because there is no post, we could not regularize them. Then page 17, we approve that.
The question of the creation of a regular post, because you are supposed to create all the posts when you are taking over the employees and the teachers and employees of the school.
Madam, what has happened, madam? Because your lordship.
What has happened? We are not concerned.
Yes, madam.
What is your promise? We are concerned with that.
But at that point of time, they are non-regular staffs and they were not within the yardstick.
What kind of yardsticks?
Yes, madam. That your lordship that what is the yardstick? I have annexed that document. Your lordship can find it to yardstick.
That the regularization staff says that considering the density of that school in the urban area.
No, that your lordship can page 13. Of my compilation.
Mr. Kuntia, there is a very simple question.
I understand.
Whether that exercise will be taken after taking over or before taking over.
Look, that yes.
That whether they are really surplus or not.
In fact, what has happened? Well, they are really surplus for only to accommodate them. Only to accommodate them, we have done this because since they have worked for 10 to 12 years, only to accommodate them, this policy decision has been taken. And why I am showing, well, they were. For a moment, you'll see the page 17.
Page 17, okay, come.
Her post was approved against a contractual post. Against that, they approved the Honorable Tribunal, saying that the 2010 is contradicted to 2004 resolution. So you regularize us from the date from 2004. Your lordship said the Tribunal dispute of the original application at page 25. Tribunal did not interfere with that, but observe that government being a model employer should take a policy decision for them. Page 32, paragraph 10. And this was challenged before this honorable court also, this was upheld. This order of the tribunal was challenged before this honorable court. Then in complaints to direction of this, of the.
Just what this.
Sorry.
That this judgment says that whether their regularization is a matter of policy decision.
Yes.
Right. This February 2, 2004 is not a policy decision of the government.
No, my lord, in tribunal has said that since this the 2004 is not applicable to them, you frame a policy decision for them. LRC has seen that paragraph 10.
No, it's right.
May I read that?
No, tribunal is also the qualification. They have everything declared. They are fit to be regularized.
Yes.
And after that, the regularization is a matter falls in the executive fiat. So we are not deciding.
And
that is the crux of this tribunal's decision.
That and in accordance, in compliance to this direction, we framed a policy.
Now, what is the division-based decision of this court? When
But
it was
that has been that decision is not with me. That was challenged before this honorable court, and the honorable court confirmed this order.
all right, but nothing in there because there is the frame a policy to regularize.
Yes, accordingly, we have framed a policy on 12/8/2016.
Now we are deciding a new matter, whether this 2004 resolution covers their services or not. Simply, this is also a policy.
LRC may see that page 35 is the next
35,
page,
yes.
page 35. Is that LRC?
Yes. That also just
And we have taken them with
that
effect
also
from.
disturbs your position that you have taken in 2010. It says that the post-contractual praise was created with effect from 28 to 2004.
Sorry, Mala, I could not.
The contractual posts were created with effect from 28
To 2004. And we have taken them with effect from 2028 to 2004. There is no dispute about it. But we have regularized them with effect from 12/8/2016, that is prospectively. And this resolution has not been challenged by them.
Which one? This one, office
Yes,
order.
this has not been challenged.
This you have not challenged.
I don't know which resolution he's referring to because he has given me a copy and he has handed over the copy.
The problem is this, Mr. Khuntia, you have not brought all the records when the writ petition was being decided
Yes,
by
sir.
the learned single
So, my
judge.
lord, what has happened, my lord, for that I have filed an additional, instead of filing a leave
You did
application.
not file any counter affidavit in the
A
writ petition.
counter as affidavit was filed before the tribunal, but that everything I cannot say, my lord, all these facts. My lord, when it came to my notice
No,
that.
because there is
I
a
saw-
problem, legal problem is there.
Yes,
Legal
but that,
problem is
that,
you have taken one stand in your counter affidavit filed before the state administrative tribunal.
yes, ma'am, that is the problem.
Now
I
you
cannot.
by your document, you cannot change that.
These are the documents, my lord, these are the documents before my lord. So instead of filing an additional affidavit, I should have filed an leave application before my lords to produce all the documents. Even what has happened, my lord, even if the writ appeal was filed, the documents are not subsequently when it.
Because the duty of the court in intercourt appeal is to look into the
Records,
legality of
I admit that. So for that reason, I want to file a leave application to obtain leave from my lords, that because these documents are vital documents.
And maybe vital because they are also not getting the opportunity.
Yes,
I do
but
not
that,
know whether,
yes, madam, that
whether you have taken these instruction from your clients, why they have not challenged this order. That order was passed on 12/8/2016. Have you not challenged? I thought this is this was challenged in the writ petition.
Just
wait. Let Mr. Senator.
Kind permission. I have just, because your lordship was discussing, let's say look to again that 28 February 2004. Your lordship, once your lordship pointed out, this is a special circumstances, you pass this resolution, which is the policy of the government by the order of the governor.
Yes.
Have you altered it? Have you changed it? You also look again. What is the purpose of that resolution? Admittedly, these persons, these 228 persons or 87 persons, they were appointed way back in 94. There is no dispute over that. And they were appointed by the municipality. Municipality, your lordship knows that is under a statutory provision under the health, that is House and Urban Development Department. They are the, you also look again to that resolution. 28 February 2004. I'm reading first paragraph. Transfer of lower secondary and secondary school of the urban local bodies to the school and mass education department was under consideration of the government for some time past. Keeping in view the justification for improvement of service condition, the school and mass education department by resolution dated 26/9/89 have declared all private school teacher of the state as a government employee with effect from 5/9/89. Accordingly, for betterment of the school and service condition of the employees working in 65 lower secondary ME school and 82 secondary schools of urban local bodies in the state, we are coming within the 82 secondary schools. Government have decided to transfer these category of schools along with teaching and non-teaching staff to the administrative control of the school and mass education department and declared the teaching and non-teaching staff of this school as a government employee with effect on the date of issue of this resolution. Now, my learned friend refer to clause 4. You also look to clause 4. Regularization of surplus staff. The school and mass education department had pointed out some surplus staff on the basis of their staffing pattern. Their own staffing pattern. These staff are not surplus as per the requirement of urban local bodies. Because of school functioning in urban areas, having higher density of the population, enroll more students than in rural area of the school under school and mass education department. These staff will be observed on the basis of the student strength as well as the additional section of these schools as per the method followed by the school and mass education department. Your lordship, with regard to the surplus staff. But so far as the non-regular service, also kindly come to clause 7 again. Non-regular services. The non-regular teaching staff 220 in number and non-teaching staff 87 in number working in these schools as on the date of taken over, that is on 28/2/2004, are also declared as government servants. But once they declared as government servant in 2004, and this resolution, this policy, this is by the order of the governor. Let's say, look to that. Let's say, look to the next page. This has been concurred by the school and mass education department and finance department dated so and so, that is 21/2/2004, and this was published in the official gazette. Now this resolution, this policy has never been altered or changed and not superseded. Now my learned friend says they were treated to be contractual in 2010 because they decided in 2006, subsequent 2004. Therefore, after 6 years, they have now been observed as a regular teacher in 2016. And they have wiped out already the service rendered by them prior to 2004, about 11 years. Admittedly. And the law you also have decided in our state also that Calicut College case, yes, M.N. Swami case, you can't wipe out the previous period of service prior to taking over. And that is why that was confirmed by the Supreme Court, and Supreme Court said a period of service has to be counted for the purpose of promotion and everything prior to the taken over. Here, the Honorable Single Judge has decided to give it in terms of this resolution of 2004, not even prior to that. We should have come in another appeal. And very unfortunate, my learned friend has not filed certain document before the Honorable Single Judge. Now, and the counter, Your Lordship, they relied upon this 2004. Now they have come forward in appeal by an additional affidavit that 2006 we have changed it, we have not challenged it. This has never been brought to the notice of the Honorable Single Judge.
No, but I fail to understand why a lot of discussion has been made in the judgment of the learned single judge regarding regularization.
Sir.
You argued the matter for regularization.
And that, Your Lordship.
Why? If this is your stand, why you have argued on regularization?
Right. But the Honorable Single Judge has also discussed many things, but our entire argument was confined to this 2004. Let's say, look to our writ application. Well, I can't.
Your Lordship, my learned senior is saying that document, Your Lordship, is page 46 for a moment that additional affidavit.
No, this petition so far regularization from 1994 has refused to grant any relief.
Yes.
And directed to regularize the steps from 28.
Our prayer was from the date of induction, from the date of appointment, but the initial appointment, the Honorable Single Judge has directed from 2000.
I think the state has a problem of a financial thing.
Yes, that has been. Your Lordship, for a moment, my Lord.
Before taken over, just Mr. Before taken over, before the resolution was passed, this policy decision was taken on 28 February 2004. There is a lot of deliberation on this. This is not in one day it has come. It has got the concurrence of the finance department. It has got the concurrence of the
May I draw my
I think what is your submission on if it is directed that on 16 days that we have created, we have regularized. Till that day, pay will be the notional and therefore get all the benefits from 16 as a financial benefit. You are agreeable to that?
Yes.
Accede to that.
Yes, I'll drop my learned senior saying that there is no opposition to that purpose. I'll only drop.
There are cases that we are just abandoning the claim of regularization from 1994 when we are appointing. They have appointed, they are not challenging the learned single judge's direction.
At least we have not challenged the law.
Secondly, now your problem may be the finance.
Yes, my lord.
So they are ready to accept these. You fix their pay and allowances notionally from 28 to 2004 to 16 when you have regularized them, and give all the financial benefits from the date of your circular.
Whole difficulties why they have come. Pensions rule they have changed in 2005.
Yes,
that is why they want that we should not.
That will protect for the other grounds also. There is a Supreme Court decision also.
Seniority and
you cannot just take it. This is an the school mother case. They went to the Supreme Court. They have regularized when some people had got only the 5 years of service after regularization. Doesn't bring the. Then one of my judgment I passed. No, at that period for purpose of pension only. Supreme Court says yes, they are serving the state, though you have not regularized, unfortunately. At least this much of benefit you should extend to them. And they are leaving the major part of their financial benefit. If this judgment is implemented, then you have to pay all the financial benefits to the petitioners from 28 to 2004. Now they are abandoning, they are ready to accept it as a notional. Now, whether are you ready to all the petitioners?
I will pursue my class. Clients are concerned.
To discuss
Yes,
because we want a solution of this imbroglio. Because some people have already
provided my Lord Friend will agree. Provided my Lord Friend will agree.
No, that goes with pass order. Whether they agree or doesn't. You come first.
Your Lordship may give me some more time so that I'll come with that pass order. I'll come with that proposition, my lord. I'll come with that proposition. What my lord.
Also record it.
What my lord.
Record it.
You just
I'll come with that. Your Lordship may give me some at least 3-4 days time that I'll
Already, you want the 8th of August?
Yes, yes.
No, 9th of August.
9th.
Eight is the first date of.
Okay, the 10th of August.
10th of
Yes,
August.
sir.
Yes.
Hard in part, all the appeals.
Well,
For continuation of hearing is the matter on 10th of August 2022. So initially on the day, it will be considered whether the benefit is granted by the impugned judgment from 28 to 2004 can be little diluted by changing the said benefit on notional basis. The parties are directed to take instructions by the next date. All right. Well,
all benefit.
All right. We need bigger skicks. Take back.
Appearances, the filed in several
At the
cases where
beginning,
the
I told you,
recorded
give the
names has not been reflected.
give the list, will reflect your name.
The copy of the petition be also served. The copy
How
of the
this
petition
you
was-
served to them.
Well, one copy.
We hope and trust Mr. Khultia will come with some.
No, otherwise you are going to pass the time. You cannot just break the someone's backbone this way. Sorry. Yes. All the other matters now, one matter.
Item 20.
Item 20,
Your Lordship,
in item 20 has filed an objection to my affidavit. Lordship may call this matter next week. I will take instruction.
All right.
11/7, you will also directed to file the reply. I have already filed the reply.
That I am saying.
Yes.
You have
Now you
filed-
want some instruction. 20. You are Mr. Behera?
My lord.
Mr. M.K. Kuntil and additional government advocate has submitted that the respondents filed the affidavit in terms of the. We passed any order to file affidavit. In terms of our order dated 11/7/2023. So Mr. Kuntil and additional government M.K. Kuntil. 6 for a short accommodation for taking instruction on the said affidavit. Let the matter be listed on 29th August 2023. All right. Mr. S. Behera and Council is appeared for the response. That's all right.
My pardon, my lord. My lord, my pardon. Item 30 be taken up today, my lord.
33.
30, my lord.
We'll try, come back at 2.
Item 42, my lord.
Well, item 74.
What adjournment?
No, my lord. No, I just want your lordship on my mention was pleased to fix it to today from 27th.
Any
Non
matter,
from
Mr.
gratuity
Chidambaram?
matter.
My lord,
Despite
Mr.
this is a-
Chidambaram is appearing.
this Mr. Shorting will
Do you have any matters, sir?
59.
I'm here for a matter listed at 2 o'clock, Lord. I'm ready.
Okay, solid. We'll take up the matter first.
That's why, my lord, I am submitting
Item
well, item
42.
74. Item 74. Okay.
Continue.
May not reach today, can be taken up tomorrow. It's a very urgent matter. Review petition was dismissed, taking an observation which is impugned with this
You
appeal.
wait. I will try to accommodate you in the course of the day if you can manage time. If we cannot manage time, we'll just list the matter in
I
a
am here
short-
for your lordship's call.
You may
If
there
it
is-
was taken up today, there's a second appeal also filed, taking advantage of the wrong, undue advantage of the observation. They're very urgent. It's become very urgent.
All right. we'll
Item
take-
42, my lord.
I
I
will-
pray
I will
may be
be-
taken up 1 week after, my lord. Item 42.
Just keep a note. Then when the matter is called out, we'll pass the order.
My-
Already will pass the order when the matter will be called out, you take a note. Okay.
Item 59.
Our matter. Yes, sir. Yes, sir.
May it please your lordships. Without appeal against the.
I'm there, state is there, I'm also there. Sir, actually,
You-
if you want
Pick
to.
up on the mic.
Yeah, mic is on.
Okay.
But will it take the whole day or to spill over to tomorrow? Tomorrow, day after, your lordship knows that other.
No, I'll
arbitration
finish in
matters.
about 45 minutes to an hour,
Right,
All right.
maximum an hour.
great.
Mr. Mishra, it's up to you whether it'll finish today or not.
Well, I'd appeal against the order of the learned single judge dismissing a writ petition against an order of the Micro and Small Enterprise Facilitation Council on the ground that there is no ground for judicial review. My lord, my submission is, the broad submission is, I have 5 grounds, but I'll summarize them presently. The broad submission is the council has completely ignored the procedure under the act, and therefore its order is a nullity. And when the order is a nullity, the learned single judge was, if I may say with great respect, obliged to interfere with that order and send it back to the council to follow the procedure. This is the broad submission. There are some other submissions that the order of the council is not on merits at all. In fact, the council does not even advert to the merits or discuss the merits. It is passing an award and it has to deal with the grounds and give reasons. It's not there. Just a minute. The other ground is that no hearing was actually granted to us before the award was passed. It's a no hearing and it's a non-speaking order. There is also a ground that some of the claims are barred by limitation, but I will come to that at the end. The main submission and the broad submission is that the council has completely failed to follow the procedure. There was an issue of maintainability raised before the council, namely that only a micro or a small enterprise, and I'm emphasizing the word enterprise for a reason which your lordships will note presently. It's an enterprise alone which can go to the council. And I have specifically pleaded that it is not a small enterprise and therefore not entitled to approach the council. It can take other legal remedies. That's on maintainability. If it is maintainable, I say that the procedure has been completely given the go-by and a non-speaking order without a hearing has been passed. Now, my lord, just for your lordship's convenience, may I hand up a list of dates? I'm not going to read every entry, my lord. Give the other side. My lord, I am a steel company and I have several suppliers. I placed 62 purchase orders according to the claim between 2009 and 2013. The claim before the council was filed in 2014. It stares in the face that a purchase order against which supply was made in 2009 or 2010 or 2011 up to March is barred by limitation. Be that as it may, he preferred a case for principal of 1 crore 93 lakhs and interest of 3 crores 4 lakhs.
Notice is issued by the council to me to file a written statement. I filed a counter statement. Now just see that portion. Instead of taking your lordship through the document, I have extracted it. If there's any error, my learned friend points out, I'll correct the error. Details of amount involved in transactions. Total basic amount was 32 crore. Total invoice amount was 36 crore. Total amount paid by me, for which I have got documents and records, 35 crore up to the last rupee, 35 crore, 31 lakhs, 85,155. And then I adjusted on account of late delivery, which is part of the conditions of the purchase order, liquidated damages for 96 lakhs. And I held back only 12,109 rupees because he did not produce a duplicate of the transport document. I have said in the counter statement, if he produces that document, I will give him the 12,109 rupees also. Anyway, Miller, your lordships in the division bench of this court need not trouble with 12,109. So I have paid and I have adjusted 96 lakhs as liquidated damages, and I've specifically pleaded that under the contract, this is a perfectly valid withholding for liquidated damages for delayed delivery. Now kindly see what the council does. Facilitation Council meeting. Millard, in this case, it held 4 hearings. The dates are given in the council's order. But the learned judge has somehow overlooked the fact that the 45th sitting of the council, he seems to have been under the impression the 45th hearing of the case. It is the 45th sitting of the council, not the 45th hearing of the case. This was heard only in 4 days, and those dates are mentioned in the order. FC found 3 invoices related to Kashipur unit. Now kindly go back to the top of the page. He has 4 manufacturing units at Khurda, Odisha, Kashipur, Uttarakhand, 2, and Chennai, Tamil Nadu. So the council felt, in respect of the Kashipur supplies, you cannot come before this council, and asked him to delete it, which he deleted. So we are left with the invoices for supplies made from Khurda, which is a unit. The enterprises Gupta Power Infrastructure Limited, a company under the Companies Act. Over the page. The respondent filed its rejoinder, it's modified its claim. I filed a reply. Then this is important. Your lordship may kindly note this date or put a mark there, whatever your lordship pleases. The council said, both of you go and amicably settle the matter. Lord, I want to emphasize the words amicably settle the matter. It was not sending us to a conciliator or an institute of alternative dispute resolution for conciliation. The council simply told parties, you go and talk among yourselves and amicably settle the matter within a month and come back to me. We came back to the council after about 4 months. The council said again, please, I'll give you 7 days. Please amicably settle the matter. And these are the exact words. Failing a response from the appellant, amount award of outstanding payment will be made. I'll show that page, Mullah, 207. I'll show that page. We filed an additional affidavit on 12.3. It was stated that there is a prima facie error in calculation of the principal amount calculated by the claimant, has not taken the liquidated damages for delay in delivery of goods, deductions on account of shortage in supply, and retention amount into account. The resultant entrance calculation is also erroneous. That is my plea. On 26, an email was sent by the appellant to the Joint Director of Industries and member convener of the council, requesting that since the settlement talks were on, no orders be passed and further requesting, this is important, issues of maintainability and jurisdiction be taken apart as preliminary issues. I'll show my lord pages 207 and 212. I'll read the document just to complete after this dates. On 24/6, appellant received a notice dated 18/6 from the council directing appearance before it on 28/6/2016 at 10 a.m. for settlement of the case. That is the word used, 214. I'll read that page also. On 28/6, what happened was, no arguments were heard on merits. The sitting was closed, and the council, not in my presence, appears to have passed an order in the case directing the appellant herein to make the payment of a principal sum of 1 crore along with an interest of 4 crore calculated up to 31/12/2014. Why I say that is, award itself came to my knowledge only on 9/8/2016 during the course of another writ proceeding, which I'm presently mentioning, in WP number 11580. Over the page, Miller. The WP 11580 was preferred by the appellant herein, challenging the jurisdiction of the council in entertaining the claim of the respondent 2 on the ground that he is not a small enterprise. Respondent 2 in the High Court brought to the notice of the High Court that the award has been passed. Hence, WP was withdrawn and the appellant was permitted to file a fresh writ petition challenging the award dated 28/6. Then appellant, even then I didn't get a copy of the award. Appellant moved an application under RTI seeking all order sheets as also the status of the case number 17. Then on 25/8/2016, award dated 28/6 was received by the appellant through an RTI. Then we filed the writ petition, WP number. I filed the writ petition challenging jurisdiction, maintainability, and of course the merits, whatever merits are there in the award. Order passed in WP. There are 3 orders passed by the learned single judge, one on 8/11, one on 4/3, and one on 7/4. My lord, the 4/3 and the 7/4 have to be read together because the 7/4 incorporates the 4/3 order. Petitioner filed the captioned writ appeal against the orders dated 4/3 and 7/4, notice issued, etc., etc. Now, my lords, kindly see the dates, pages I mentioned, where the council simply asks us to amicably settle, and we come back to the council. It says 7 days to settle. We come back to the council, no arguments heard, and an award is passed. Now, kindly see the act. It'll only take a few minutes for your lordships to appreciate the scheme of the act. Act called the Micro, Small, and Medium Enterprises. Well, this act, I'll just show a few sections and then show the procedure to be followed, and then cite the 2 judgments of the Supreme Court, which clearly say that if the procedure is not followed, the so-called award is a nullity. Now, kindly see, my lord, section 2E. 2E defines the word enterprise. It's not defining the word unit. It's defining the word enterprise. Enterprise means an industrial undertaking or a business concern or any other establishment, by whatever name called, engaged in the manufacture or production of goods in any manner pertaining to any industry specified in the first schedule, or engaged in providing or rendering of any service or services. So it's an enterprise. It may have one manufacturing unit. It may have multiple manufacturing units. It's an enterprise. Then now kindly see section 2M, M for mother. Small enterprise means an enterprise classified as such under subclause 2 of clause A or subclause 2 of clause B of section 7.1. Milord, 7.1A2 deals with a supplier of goods. 7.1B2 refers to a supplier of services. So that's why there are two sections. Next definition, supplier. Supplier means a micro or a small enterprise which has filed a memorandum with the authority referred to in subsection 1 of section 8 and includes, kindly Miller, look at italics 3, any company, cooperative society, trust or body, by whatever name called, registered or constituted under any law for the time being in force, and engaged in selling goods produced by micro or small enterprises and rendering services which are provided by such enterprise. Now, my lord, the claim can be filed by section 18 only a small or medium enterprise is covered under the act to go before the council. I'm sorry, micro and small. Micro and small. Micro is in 2H and small, which I read, is 2M. We are not concerned with the micro. Now, my lord, the definitions are in 7.1A2, as I said, supplier of goods. 7.1A2, notwithstanding anything contained in section 11B, etc., central government may, for the purposes of this act, by notification and having regard to the provisions of subsections 4 and 5, classify any class or classes of enterprises. Again, my lord, the word is enterprises, whether proprietorship, HUF, association of persons, cooperative society, partnership firm, company, or undertaking by whatever name called. So a company will be an enterprise. A2, in the case of the enterprise engaged in the manufacture or production of goods pertaining to any industry. 2, a small enterprise where the investment in plant and machinery is more than 25 lakh rupees, but does not exceed 5 crore rupees. If it exceeds 5 crore, Miller, it becomes a medium enterprise and therefore not covered under this act. I've specifically pleaded its investment in plant and machinery exceeds 5 crore, and therefore it is not entitled to approach the council, and therefore their application is not maintainable. Now, Millet, kindly come to section 18, which is the heart of the matter. Notwithstanding anything contained in any other law for the time being in force, any party to a dispute may, with regard to any amount due under section 17, make a reference to the Micro and Small Enterprises Council. On receipt of a reference under subsection 1, the council shall, my lord, I emphasize the word shall either itself conduct conciliation in the matter or seek the assistance of any institution or center providing alternate dispute resolution services by making a reference to such an institute or center for conducting conciliation, and the provisions of section 65 to 81 of the Arbitration and Conciliation Act shall apply to such a dispute as if the conciliation was initiated under part 3 of that act. So, my lord, conciliation is mandatory. Council may conduct the conciliation itself or may refer it to an institute of alternative dispute resolution. But the conciliation shall be in accordance with section 65 to 81 of the Arbitration Act. Then 3, where the conciliation initiated under subsection 2 is not successful and stands terminated without any settlement between the parties, the council shall, again, shall, either itself take up the dispute for arbitration or refer it to any institute or center providing alternative dispute resolution services for such arbitration, and the provisions of the Arbitration and Conciliation Act shall then apply to the dispute as if the arbitration was in pursuance of an arbitration agreement referred to in subsection 1. So again, the act is attracted. You have to go through the entire procedure, claim, counter, etc., and go through the procedure, hear parties, and pass a reasoned award. Notwithstanding anything contained in any other law for the time being in force, the micro council or the center providing alternative dispute resolution shall have jurisdiction to act as an arbitrator or conciliator under this section in a dispute between the supplier. Well, this has been interpreted, and if I may say with great respect, correctly. Under the Arbitration Act, a conciliator cannot be an arbitrator. But here, this power is given to the council or to the ADC. You can be a conciliator. You can also, failing which, arbitrator. Every reference made under this section shall be decided within a period of 90 days from the date of making such a reference. And if an award is made under 19, I have to apply for setting aside the award. Shall be entertained by any court unless I deposit 75%. So the court has been held to be Millard under section 34. There's no dispute about all that. Now, therefore, Millard, my submission is 18.2 requires mandatory conciliation. It should end in a settlement or in a failure of conciliation. 18.3 requires mandatory arbitration. In either case, both conciliation and arbitration follows the procedure in the Arbitration and Conciliation Act. Now, Millard, what happened in this case can be gleaned from 3 pages, which I have emphasized. Just kindly look at the pages. Kindly go to page 202. Writ Appeal, main volume, 202. Just 3 or 4 pages have to be read, Miller, to show what exactly happened before the council. 202. Well, it actually starts at 198, annexure 14. I'm not reading it. The history of the case is set out. At page 199, 3rd paragraph, after thorough examination, it is found that the petitioner has submitted 3 numbers of tax invoices from Kashipur, which is not the jurisdiction of MSFEC Orissa. Petitioner should comply, which is removed. Over the page, counter is set out. At 201, the rejoinder is set out. The rejoinder goes up to the end of page 201 and then 202. The OP filed time petition to file the counter to the rejoinder. Then order. The council allowed 15 days and directed the parties to have an amicable settlement within 1 month as agreed upon and report the same. Well, this is not, in my respectful submission, not a reference to conciliation. This is say you go and talk among yourselves. Next page
So
is,
according to you, this is the failure number one, so far the procedural law is concerned. This is the
Yes.
failure number one.
failure number one.
Yes.
Well, this failure unfortunately continues right through until the so-called award. I'm sorry, but that is apparently the council is completely misdirected in law. Then 203 is the next date, 21/2016. Again, my lord, the same procedure. It's all repeated. History of the case, the claim, the counter, and then the rejoinder. All that is repeated up to 206 and 207. Now kindly see 207. The second order passed. Both the parties were present before the council in its 42nd sitting. Well, it's not the 42nd hearing of this case.
Yes.
It's effectively the second one. 42nd sitting. Well, apparently this council numbers the sittings as 1, 2, 3, and I'm told it's now running to 109, I'm told. So if 109 sitting does not mean in that case, there are 109 hearings. Many cases are heard. Anyway, 42nd sitting. The petitioner submitted before the council that the case is pending since 24/4/2014 and the unit is facing financial hardship. Initiating the discussion, the advocate on behalf of the OP, that is my client, submitted before the council that the management of Gupta Power Infrastructure Limited, that is the claimant, is in touch with the management of JSW Steel to have amicable settlement and prayed 7 days' time to intimate its outcome to the council. In response to it, the representative of the petitioner declined to have such information. Well, what he means is, I do not have such information. As a result, the council may go ahead towards disposal of the case. The council went through the deliberation made by both parties. The council directed the OP to have amicable settlement with the petitioner and inform its outcome to the council in writing within 7 days from today. If no communication is received from the OP within the stipulated period, well, this I object to. I say it's wrong. Award shall be given for payment of the outstanding dues. Well, it's a completely predetermined approach. Either you report settlement or I will pass an award for the outstanding amount with interest. Be that as it may, Miller, it could have still dealt with the merits. This is the second order. The third order, my lord, is, the third document is page 212. This is an email that my client sent to the member convener of the council. Your lordship may only read the last 2 lines at 212. In view of the offer, Milord Gupta made an offer. In view of the offer made by Gupta Power Infrastructure and our response to the same, we request this Honorable Council not to pass any orders. However, if this Honorable Council decides to pass orders on merits, proper opportunity may be kindly given to JSW to lead evidence and to place its arguments in the reference case. We reiterate our stand in the counter affidavit, reply to the rejoinder and additional affidavit. However, we also request this Honorable Council to decide the following preliminary issue before passing any orders on merits. 1, whether the Gupta Power is an entity under the MSMED Act and whether the claim made before the council is maintainable. Whether this Honorable Court has a jurisdiction to entertain the claim made by Gupta in view of the arbitration clause in the purchase order. Your lordship need not trouble with the issue, but I said, please give me an opportunity. I will lead evidence. I will argue the matter. And these issues of maintainability and jurisdiction may also be decided. This is on 20th June. At 2:14, this is on 24th June, 4 days later. Take notice that the 45th sitting of the council is scheduled to be held on 28th of June. You are hereby directed to appear in person or through duly authorized registered advocate in the council on the scheduled date and time for settlement of the case. Take notice that in default of your appearance on the day mentioned above, council shall proceed as per the provisions of the FC rules under the FT Act. My lord, this gave me the impression that if I appear and there is no settlement, they will proceed according to the Act and the rules. Then, my lord, what happened is at 216, this is 28th of June. Please see what happens. This is the last sitting, fourth sitting. It sets out the facts at 216. 217 also, the various claims, etc., is set out. Then middle of the page, 217. Both the parties, no, I'm just before that. OP filed time, council allowed 15 days and directed both parties to have an amicable settlement. Both the parties were present on 20th of January. Petitioner submitted that the case is pending since 24th April and the unit is facing financial hardship. Initiating discussion, all this is a repeat of the earlier order, Miller. I pointed out amicable settlement and prayed for 7 days, and the last 3 lines. The council went through the deliberations made by both the parties and directed the OP to have amicable settlement with the petitioner and inform its outcome within 7 days. If no communication is received within the stipulated period, award shall be given for payment. All this is a repetition of the earlier order. Then over the page is another repetition. The counter is extracted at 218. The rejoinder is extracted at 219. All this is from the earlier order, your lordship will recall. And now 220. Then in view of that, up to that the counter, then both the parties were present before the council in its 45th sitting on 28 June. That is the date of this so-called award. The petitioner has stated that the case was pending since 24/4 and the case may be decided by the council as per the Act. OP stated petitioner was not a small-scale unit. The council examined the PMT registration certificate and concluded that the unit is an SSI unit. Further, the council observed that this case was heard on 29/12, 27, and 21. There was no hearing on merits, only giving time to settle. The council had directed the OP in its 42nd sitting to make an amicable settlement in writing within 7 days. But the conciliation has failed. There was no conciliation. In the meantime, the OP filed additional affidavit. Petitioner filed its counter. Council went through the relevant documents filed by the OP on 27/1 and 21/4 and the counter on 28/6, that is the very day, and decided to pass an award as follows. Since the amicable settlement failed, the OP is hereby directed to pay the principal amount of 1 crore together with the interest of 4 crore calculated up to 31/12, further compound interest, etc. There's no discussion on the merits of the case. There's a complete failure of the procedure. And the pleadings are complete, but then there must be a discussion on merits. I prayed for leading evidence, addressing arguments. It says I've got a certificate and certificate shows it's an SSI unit. That's not relevant, my lord. Certificate is for Kurda unit. I'll show that certificate in a moment. But my lord, the broad question of law is more important. Just kindly see 2 judgments of this Honorable Supreme Court, which according to me concludes the matter. The first one is 2021 SCC online 1257. 2021, SEC Online 1257. But I'm not citing multiple judges,
Yes.
only 2 or 3. Now kindly come to, this is a look at paragraph 2, Miller. The last 4 lines of paragraph 2. The council issued summons dated 18/7 for appearance of the appellant on 6/8. Only on the ground that on 6/8 the appellant has not appeared, the order dated 6/8 was passed by the council directing the appellant to make the payment of the third respondent as claimed within a period of 30 days. The said order was under challenge before the High Court by way of a writ petition, and the same was dismissed by the learned single judge. An intra-court appeal was also ended in dismissal, hence this appeal. Paragraph 5. It is mainly contended by learned counsel for the appellant, as there were some disputes on the supplies made by the third respondent. The bill amount was due was not paid. It is submitted not only on the ground that the appellant has not responded in the conciliation proceedings. Straight away, the order which was passed by the council without giving proper opportunity. The order impugned in the writ petition was passed in utter disregard of the mandatory provisions under section 18. Well, the provisions are extracted, arguments are extracted. Now kindly come to paragraph 8, Miller. At 8, in the writ petition of the appellant has challenged the order award dated 6/8, passed by the second respondent council constituted under the provisions of the Act. The third respondent has approached the council seeking directions against the appellant for payment of delayed bill. Immediately after filing application by initiating conciliation proceedings, council has issued notices, and as appellant has not appeared, summons were issued to the appellant on 18/7 for appearance on 6/8. The relevant portion of the summons dated 18/7 reads as under. The first paragraph I'm not reading. You are directed to produce. Then take note that in default to your response within the period mentioned above, the dispute shall stand terminated. Otherwise, the dispute shall be heard and reconciled with a view to the settlement of dispute. And in case settlement is not arrived at, the council shall either itself act as an arbitrator for final settlement of dispute or refer it to an institute for such settlement. Only on the ground that even after receipt of summons, the appellant has not appeared, the council has passed the award. And then the sections are set out, and kindly see from paragraph 11 over the page. From a reading of section 18.2 and 18.3, it is clear that the council is obliged to conduct conciliation for which the provisions of section 65 to 81 of the Arbitration Act would apply, as if the conciliation was initiated under part 3 of the said act. Under section 18.3, when the conciliation fails and stands terminated, the dispute between the parties can be resolved by arbitration. The council is empowered either to take up arbitration on its own or refer the arbitration proceedings to any institute, etc. It is open to the council to arbitrate and pass an award after following the procedure under the relevant provisions of the Arbitration Act, particularly sections 20, 23, 24, 25, which your lordships know, claim, counter, etc. There is a fundamental difference between conciliation and arbitration. All that is set out, Miller. Then paragraph 13. If the appellant had not submitted its reply at the conciliation stage, he did not turn up in that case, and failed to appear, the facilitation council could, at best, have recorded the failure of conciliation and proceeded to initiate arbitration proceedings in accordance with the relevant provisions of the Arbitration Act to adjudicate the dispute and make an award. Proceedings for conciliation and arbitration cannot be clubbed. In this case, only on the ground that the appellant had not appeared in the proceedings for conciliation on the very first date of appearance, that is on 6/8/2012, an order was passed directing the appellant and or its etc. Jharkhand State Electricity to pay 78 lakhs towards the principal claim and rupees 91 lakhs towards interest. As is clear from the records of the impugned proceedings, Facilitation Council did not initiate arbitration proceedings in accordance with the relevant provisions of the Arbitration Act. The order dated 6/8/2012 is a nullity and runs contrary not only to the provisions of the Act, but contrary to the various mandatory provisions of the Arbitration Act. The order dated 6/8/2012 is patently illegal. There is no arbitral award in the eye of law. It is true that under the scheme of the Arbitration Act, an arbitral award can only be questioned by way of application under Section 34, so also in 19. At the same time, when an order is passed without recourse to arbitration and an utter disregard to the provisions of the Arbitration Act, Section 34 will not apply. We cannot reject this appeal only on the ground appellant has not availed of the remedy under Section 34. The remedy under Section 34, the submission of the learned senior counsel, etc. There was a delay in latches. We're not getting into that. Next page, my lord. Fifth line. Thereafter was filed questioning the order dated 6/8 before the Rajasthan High Court. In that view of the matter, it cannot be said there was abnormal delay, etc. That's about the delay, my lord. And then last 4 lines of that paragraph 15 have placed reliance on certain judgments of the case, but as the order dated 6/8/2012 was passed contrary to Section 18(3) and the mandatory provisions of the Arbitration Act, we are of the view that such judgments would not render any assistance. Civil appeal is allowed. Impugned judgment on order is set aside. Order dated 6/8/2012 filed by the passed by the second respondent stands squashed. However, it is open to the second respondent counsel to either take up the dispute for arbitration on its own or refer the same to any institution, etc., etc. My lord, I need not emphasize, my lordship, nullity, patently illegal. You have to pass an order under the Act.
Yes.
So the next judgment follows this judgment is Vijita Construction. It is Civil Appeal 5394 of 2021. Please, you've given. It's on the same lines, my lord. 2 learned judges. Kindly see the first paragraph. Leave granted. Feeling aggrieved and dissatisfied with the impugned judgment on order by the High Court of Chhattisgarh, by which the High Court has dismissed the said writ petition as not maintainable in view of the remedy available to the original petitioner under Section 34 of the Arbitration Act, the original respondent number 1 has preferred the present civil appeal. Dispute arose between the parties which could not be resolved. Case was that it supplied TMT bar, etc., etc. Referred to the counsel. Then para 3. By order dated 10/1, the Facilitation Council closed the said proceedings by observing that the Facilitation Council has been constituted with limited object and jurisdiction, and the council has no jurisdiction to make thorough inquiry and take evidence and decide the truth about the challenged document. The council also observed parties are liberty to move the competent court. Feeling aggrieved and dissatisfied, respondent herein preferred writ petition before the High Court of Chhattisgarh. For the impugned order, the High Court has dismissed the said writ petition by observing order passed by the council rejecting the application can be said to be an award under Section 18 and as per section 18(2) and 3, the provision of the Arbitration Act shall apply. Arbitration was in pursuance of an arbitration agreement, and therefore such an order would be amenable to appeal under 34. That is what the High Court's reasoning. Feeling aggrieved and dissatisfied with the impugned order passed by the High Court, writ petition preferred by the respondent herein, however, holding that the order passed by the Facilitation Council rejecting the application can be said to be an award, and therefore, as per the provisions of the Arbitration Act, shall apply as if the arbitration was in pursuance of an agreement under subsection, etc., etc. The original respondent has preferred the present appeal. Learned counsel appearing on behalf of the appellant has vehemently submitted that the case or order of the Facilitation Council cannot be said to be an award, did not conclusively settle the dispute. They submitted, etc. All that is there, Miller. And over the Lordship may skip all that. Paragraph 9. Just a moment. Paragraph 9. It sets out the sections 15, 16, 17, and 18. And then kindly come to 9.1. Therefore, as per the scheme of the MSMED Act, when there is a dispute between the micro and small enterprises, supplier and buyer, the same is required to be resolved by following the procedure under 18. As observed here and above, MSMED Act is a special act, shall have overriding effect. Therefore, section 18 of the MSMED Act would have overriding effect over any other law for the time being in force. The said dispute is to be resolved only through the procedure as provided under section 18 of the Act. Then the sections are summarized again. Now kindly come to the last part of that. Is the same copy? Different copy. Thus at the page 9, the last 4 lines. Thus at the stage of conciliation, the counsel conciliator have to bear in mind the provisions of section 65 to 81 of the Arbitration Act. Your Lordship knows that provisions, but nevertheless, my Lord, the Supreme Court has extracted the sections. 65, submission of statement before the conciliator, conciliator not bound by certain enactments. 67, role of conciliator. 68, administrative assistance. 69, communication between conciliator and parties. 70, disclosure. 71, cooperation. 72, suggestions. 73, settlement. 74, status and effect of settlement agreement. 75, confidentiality. Then 76. The conciliation proceeding shall be terminated by the signing of the settlement agreement with the parties on the date of agreement, or by a written declaration of the conciliator to the effect that further efforts at conciliation are no longer justified on the date of the declaration, or C, by a written declaration of the parties addressed to the conciliator, though the conciliation proceedings are terminated. Only one of 3 ways in which the conciliation proceedings, or by a written declaration to the other party to the effect that the conciliation proceedings are terminated on the date of declaration. Then resort to arbitral or judicial proceedings, then costs, deposits, etc. Then para 9.2 at page 14 of the judgment. As per subsection 3 of section 18, after conciliation fails under subsection 2 and conciliation initiated under subsection 2 is not successful, conciliation stands terminated without any settlement. The council shall either take upon itself the dispute for arbitration or refer it. All that is set out, my Lord. Your Lordships are familiar. Last 2 lines. Therefore, only after the procedure under subsection 2 of 18 is followed and the conciliation fails, and then only the arbitration proceedings commences, and thereafter the provisions of the Arbitration Act shall apply. In the light of the aforesaid statutory provisions under the Act, the order passed by the Facilitation Council on 10/1, which was a subject matter before the High Court, is required to be tested. From the order passed by the Council, rejecting, dismissing the reference application and the stage at which such an order was passed, we are of opinion that the council has not followed the procedure as was required to be followed under section 18, read with section 65 to 81 as reproduced here and above. It is required to be noted at the initial stage, the council was performing the duty as a conciliator, for which the provisions of 65 to 81 shall be applicable. It is true that at that stage of conciliation, the role of conciliator is to assist the parties to reach an amicable settlement, etc., etc. At that stage, the parties are not required to lead evidence, and at that stage, the role of conciliator is not to adjudicate the dispute, but to reach an amicable settlement. Once the conciliation fails, thereafter, as per subsection 3 of 18, the arbitration proceedings commences and the conciliation proceedings stand terminated, and thereafter the council shall either take upon itself or refer it to an institution as center, as if the arbitration is in pursuance of an arbitration agreement. At that stage and thereafter, the council shall act as an arbitrator, and the provisions of the Arbitration Act shall then apply, etc., etc. Then, para 10. In the present case, no such procedure has been followed by the council as required to be followed under section 18. It is to be noted that the proceedings before the council was at the stage of conciliation. It is true, at the stage of conciliation, the conciliator was not required to permit the parties to lead evidence. At the same time, if there was no amicable settlement during the conciliation under subsection 2 of section 18, then the arbitration proceedings were required to be initiated as provided under subsection 3 of section 18. Therefore, as such, the matter is required to be remitted to the council to follow the procedure under section 18 by quashing and setting aside the order of dated 10-1 passed by the council, as well as the impugned judgment passed by the High Court in writ petition number 418. Now, so far as the observations made by the council in order dated 10-1, that the facilitation council has been constituted with limited object, well, that they say it's completely wrong. You are not limited object, etc. I'm skipping paragraph 11, para 12. In view of the above, and for the reasons stated above, the order passed for the council dated 10-1, as well as the impugned judgment of the High Court are set aside. Matter is remitted to the council to decide afresh in accordance with the law and its own merits after following the procedure as required under section 18, as a dispute is very old. Well, in first case, it is order dated 6-8. This was an order dated 10-1. Both cases, my lord, the procedure was not followed. It is a nullity, patently illegal. In our case, my lord, the first case is I'm much better. I appeared. The first case before Justice Reddy and Justice Banerjee, the party didn't appear and he said direct payment. I appeared. He said, go and settle among yourselves. We came back. I asked, give us 7 more days. He said, 7 days, come back. And we came back. On that day, we reported there's no settlement. He should have initiated conciliation. He should have conciliated himself or referred it to conciliation. And that conciliation, as Justice Shah points out in the second judgment, follows an elaborate procedure. Lord, the council, if I may say with respect, after I read the act on the judgment, the council is not short-circuiting the procedure for conciliation and arbitration in the Arbitration and Conciliation Act. All that the council is doing is taking over the functions of a private conciliator, taking over the functions of a private arbitrator appointed by the parties. The council has to conciliate and arbitrate. And the procedure is exactly as in the Arbitration and Conciliation Act. You can't short-circuit it and say, I'm not bound to follow the Arbitration and Conciliation Act, either for conciliation or arbitration. I will have my own summary procedure and I'll read the claim and dismiss it. Well, that's simply not allowed. You have to go through the procedure of 65 to 81 for conciliation and go through the procedure of 22 to 26 for arbitration. And my lord, your lordship may just glance at the Arbitration and Conciliation Act. I'm not reading the provisions. Just glance at the Arbitration and Conciliation Act for completion. 65, my lord, starts in part 3 is conciliation. The entire procedure is set out 61 to 74. After the appointment of a conciliator, in this act, the council itself can be a conciliator. 65, a submission of statement, role of conciliator, communication between conciliator, role of conciliator, all that is set out elaborately, and it has to end up with a settlement agreement under 73, not settled, 76, termination of conciliation proceedings and a report. This procedure was not followed. Now, the second stage, we come to arbitration. That starts at section 21, commencement of arbitral proceedings. 22, language. 23, statements of claim and defense. 24, hearings and written proceedings. Kindly see, Miller. Unless otherwise agreed between the parties, the arbitral tribunal shall decide whether to hold oral hearing for the presentation of evidence or for oral argument, whether the proceeding shall be conducted on the basis of documents and other materials. I have asked for a hearing and to lead evidence. 25, default of a party. 26, expert. 27, court assistance in taking evidence. Then, my lord, 28 is rules that will apply. 29, unless otherwise agreed by the parties, the arbitral proceedings with more than one arbitrator. Here there are 5-member council. Any decision of the arbitral tribunal shall be made by a majority. 29A, time limit for arbitral award. 29B is fast track procedure. 30 is settlement. 31, an arbitral award shall be made in writing and be signed by the members of the arbitral tribunal. For the purpose of the subsection 1 in arbitral proceedings with more than one arbitrator, signatures of the majority of all the members of the arbitral tribunal shall be sufficient, as long as a reason for any omitted signature is stated. The arbitral tribunal shall state the reasons upon which it is based, unless the parties have agreed that no reasons are to be given. We have not agreed. Award is an arbitral agreement on agreed terms, etc., etc. And then, my lord, arbitral award shall state in date and place of the arbitration. After the arbitral award is made, a signed copy shall be delivered to each party. I did not even get a copy. I got it through an RTI. Arbitral tribunal may at any time during the arbitral proceedings make an interim arbitral award. Then, unless otherwise agreed by the parties, arbitral tribunal may include in the sum for which the award is made interest, etc. Regime for costs is set out. Then 32 is termination of proceedings. The arbitral proceeding shall be terminated by the final arbitral award or by an award of the arbitral tribunal under subsection 2. Then correction, etc. Lord, I submit, my lord, neither procedure of conciliation nor the procedure of arbitration was followed in this case. It's a complete nullity. My lord, all my grounds are covered except one. The procedure was not followed. No hearing granted, not speaking order. All those grounds are covered. It leaves, my lord, 2 points. One, it is not a small enterprise, which of course, my lord, I have to urge before the council. I mean, I can submit to your lordship the facts, but the council has to look at the evidence and decide it's a small enterprise. Well, just kindly, for prima facie, this is a solid ground. I've pleaded it repeatedly. The page 66 to 69 are the unit registration certificates produced by the claimant. Page 66 to 69. In 66, my lord. Where is that investment number? Just a moment. No, 66, my lord, I don't know if your lordships can read it. It is the better page is at there's one page 66, annexure 3. Skip that page, and the next over the page there is a better copy. This is the Kurda unit. It's got a certificate from the DIC Bhubaneswar that it is a small unit. My lord, micro is 1, small is 2. Does your lordship have this page?
Yes.
Your lordship. Small is 1. I'm sorry, micro is 1, small is 2, medium is 3, against which he has put 2. It's a small unit. The Kurda unit is a small unit. Then at page 68, you get from the DIC Kashipur, which is in Uttarakhand. The original certificate at page 68 says it's small. The number is 2, but at 69, it is corrected to 3 against 3 because it has made additional investment. So the Kashipur unit is classified as medium, which is not entitled under this act. Then 70, the Chennai unit is classified as 2, small. So what do we have? We have an enterprise with 3 units. Kurda is small, Kashipur is medium, Chennai is small. According to me, the unit certificate is irrelevant. What matters is the enterprise. An enterprise, your lordship saw, who can make a claim, is a company or an HUF or a partnership or an association of firms. The enterprise may have more than 1 unit. It is the investment in the enterprise that matters. And the investment, my lord, is at page 86. His own annual return, annexure 7. Now kindly see, my lord, the company, the enterprise is Gupta Power Infrastructure Limited. Yes, ma'am. Kindly see in page 86, the 3rd line, plant and machinery. Just run through the line, my lord. Net block after depreciation, net block was 345 lakhs as on 31/3/2010, but it has become 654 lakhs on 31/3/2011. Above 5 crore, 6 crore 54 lakhs. The same number your lordship will get.
Just a pause. Just let us see. It's not readable on our scan copy.
It is annexure 7, page 86, 3rd line. Rupees and lakhs, 3rd line, plant and machinery. The last 2 columns. Yes. Closing balance on 31/3 is given as 345 lakhs. But on 31/3/2011, it's 654 lakhs. The better statement is the next page 87, note 9 on fixed assets. The 3rd line, plant and machinery. Kindly come to the last column. On 31/3/2011, it is 654 lakhs. On 31/3/2012, it was 547 lakhs because of depreciation. But both are above 5 crore. This is a point I've raised from day one, and the council is bound to decide whether he falls under the category of small or has exceeded the investment. No, that is your statement. And I have produced a chartered accountant certificate at page 290,
What is page 88?
based on his
What is page
financial
88?
statements.
What kind of document is this? Page 88. What it can be-
68. Yes,
No,
88.
88.
Yes. Yes. This is the same chart, Murad.
Okay.
Plant and machinery. We prepared it. But I've taken it from the previous pages. 345 lakhs. Gross is 886. This is gross, Mallard.
Yes.
867. I don't think gross is correct. To be fair to him, I must take the net. But I've shown the net, Mallard, at the 2 pages. I've shown the net numbers of the 2 pages. At page 86 and 87. 86 and 87. 87, for example, in March 2011, it was 654 lakhs. In March 2012, it has come down to 547 lakhs, but both are above 5 crore. Now, the clearer picture your lordship will get in a chartered accountant statement certificate at 290. 290. In fact, my lord, the chartered accountant has gone it unit by unit and has put all the units there. Investment as on 31/3/2011 and 31/3/2012. Unit-wise, Kurda is under 5 crore. But the total enterprise, if you take, it is above 5 crore. Look, this is a point I must urge before the council. If he gives me an opportunity to place his material, and he can come to a conclusion. The council may come to a conclusion.
And this part has been clearly discarded by a single judge.
Subsequent one. This I will argue before the council, my lord, if the council either holds conciliation or arbitration in accordance with the act. Why? What was he saying? I don't understand. I'll read this.
That he discarded the proposition. This
I beg
part.
pardon?
This
I'm not able to hear your lordships.
all right. So just these clubbing up to of the matters. He says that it cannot be accepted because there is no rule.
My lord, whether it's clubbing, that circular was issued and withdrawn. I'm not disputing that. So I'm not even referring to the circular. I'm going by the provisions of the act. Act says enterprise can apply, not unit. What is an enterprise? An enterprise is, your lordship saw the act.
Oh, it has been defined.
Enterprise under section 7. Where's that? Under section 7, kindly see, Miller. Section 7. Please see 7. Where is the enterprise, company,
Yes.
etc.? No. Other section. Apply, and just a moment. 7(1). Just a moment. Where is it? Enterprise, HUF, etc.
7. Association persons cooperative.
7, na?
7(1).
Yes. Now kindly see, my lord, 7 of the act. Notwithstanding anything contained in section 11B, the central government may, for the purposes of this act, by notification and having regard to the provisions of subsection 4 and 5, classify any class or classes of enterprises, whether proprietorship, Hindu undivided family, association of persons, cooperative society, partnership firm, company, or undertaking, and then the investment figures are given. Between 25 lakhs and 5 crore for the small enterprise. Micro enterprises less than 25 lakh and medium is over 5 crore. So it is really the enterprise, investment in the enterprise which matters. Not a unit of an enterprise. An enterprise can have multiple units. It can have a manufacturing factory in one part of, say, Cuttack, and it can have one in Bhubaneswar. That doesn't mean it can treat each one as an enterprise. That's why, my lord, this definition is important. Enterprise, classify enterprises, whether proprietorship, HUF, AOP, cooperative society, partnership firm, company or undertaking, not each unit, my lord. Then he can break up a unit and then I'm micro, I'm small. Therefore, this is a question which I submit. The council must allow me to argue.
Okay, this question is
That's the point.
well attended. Okay.
No, that I forget. That is, well, the two circulars which the learned judge, I'm not even referring to them. That was issued 2 months later, was withdrawn. I'm not even referring to. I'm going by the act. I'm going by the act. The other point, my lord, is that in the writ petition, I've squarely raised the ground of limitation. It stares in the face. 2009 supply, you file a claim in 2014. Any claim prior to April 2011 would be barred by limitation. And, my lord, the judgment of the Supreme Court, which holds that Limitation Act applies, is 2021 SCC Online, Supreme Court, page 439. And that is the last judgment I'm citing. 2021 SCC Online, Supreme Court, page 439. Kindly, my lord, come to, what have you given, SCC Online? What have you given? SCC Online. Now kindly come to paragraph 13. The question is posed whether the provisions of the Indian Limitation Act is applicable to arbitration proceedings initiated under section 18(3) of the MSMED Act. Answer, my lord, is in paragraph 18 at page paragraph 18, last 4 lines. I'm not reading the reasoning, Miller. Last 4 lines just before para 90. Thus, we are of the view that no further elaboration is necessary in this issue, and we hold that the provisions of the Limitation Act will apply to arbitrations covered by section 18(3) of the Act. We make it clear that as the judgment of the High Court is an order of remand, we need not enter into the controversy whether the claims, counterclaims are within time or not. We keep it open to the primary authority to go into such issues and record its own finding. So Limitation Act clearly applies. What for? 2009 invoices. No, I've sold that.
I think you have done it.
Invoices, my lord, start with 2009 and end with 2013. So part of the invoices would be barred by limitation. The last point on merits, again, I can't urge it before your lordship and ask your lordships to give a finding. Counsel, I pleaded liquidated damages. Now please see one purchase order as a sample. 18, huh? Once purchase order, every purchase order has this clause. 85. It's the purchase order starts at 75. Just I'm showing one sample purchase order. Annexure 6 starts at 75. kindly come to page 80, clause 10. Liquidated damages. The rate of liquidated damages for late delivery shall be 0.5% of total contract price per week of delay or part thereof for the first 4 weeks thereafter, 1.5% of the total contract price per week of delay or part thereof, subject to a maximum of 5% of the total contract price. Cumulative liquidated damages for late delivery shall not exceed 5% basic contract price. My lord, you hardly need to say all this. Each contract is each purchase order constitutes a separate contract, because the second purchase order is a different contract. He accepts it, he supplies. Each purchase order contains the liquidated damages clause. So wherever there was delay in delivery, I have deducted liquidated damages. And in the first statement, very first pleading, I said I've held back 96 lakhs for liquidated damages. Now the tribunal should go into the question and decide whether liquidated damages was rightly levied or not. But these last 3 points are on merits.
Yes, that because this
Last 3 points which
yes
are on merits. Limitation, liquidated damages, whether it's a small enterprise, I have to show the evidence or lead evidence and ask for a finding. But all that could be availed of by me only if a hearing was conducted in accordance with either conciliation or arbitration. Neither conciliation nor arbitration took place in this case, and therefore this writ petition ought to have been allowed and the matter should be remanded.
Thank you, Mr.
I'm deeply
Chidambaram.
obliged. Lord, I took 10 minutes more than I promised. I'm sorry.
Mr. Mishra, you would you address us today?
Sir, I cannot finish today, but I can start today, my lord.
No, that is useless. Then you start on a fresh date. Because we have not done our board so much today. So we are marking it as a part, a short date will provide.
Right.
And you conclude on that day. So it can be done on 10th. 10th is any matter as to. We are fixing on 10th of August at 2 p.m. again.
12th of August.
10th of August.
Sir, 10 to 15, my friend will not be there. He is actually briefing me in fact this matter. After 15th, any day you'll be fixed.
Then on 18th, no? Then it will go to 23rd of August.
17th.
23rd of August.
23rd.
Heard Mr. P. Chidambaram and its senior counsel. Who is assisting Mr. Chidambaram? You?
I beg pardon.
You give the list, huh?
Okay.
Substantively.
Myself and Mr. Ankur Saigal are appearing.
All right. But Mr. S.P. Misral and his senior counsel appearing for the respondent. You're for respondent number 2. Could not respond to the submissions for short of time. Let the matter be listed on 23rd of August 2023 at 2 p.m. for continuation of hearing is parted. Who is appearing for the state in this matter? There is a 2 state respondents. T.K. Mohanty.
Respondent number 1.
Only respondent number 1, 3?
Yes, 3B. Yes.
3 also.
Yes.
An additional government advocate appears for the respondent number 1 and 3. It's okay. It will be taken up again on 23rd, Mr. Chidambaram.
Very well.
Yes.
I have noted the date, madam. I'm deeply.
Mr. Patnaik, you are assisting Mr. Mishra.
For the hearing.
Okay, then his case. And you please keep the list. Tell him petitioner's counsel's list should be given. Please is given. Call item number 58.
Item 58.
Oh, grateful.
Yes, I have filed the e-copies of the affidavit dated 19/7/2023. This time filing the hard copies also. It is a matter of the petition has been filed by the state because some difficulties were faced to carry out the orders passed by the Honorable Apex Court in the case of Mohanlal. And by order dated judgment dated 31st January 2022, this Honorable Court has passed some guidelines for disposal of drugs. And thereafter it is being monitored by this Honorable Court.
Yes.
And in the meantime, we have disposed of around 275 tons of ganja. Plus, we can peruse that affidavit so that
yes,
I have given it table. Page 2. Table at page 2 plus for losses immediate perusal. The pre-trial disposals for ganja is concerned is 262 tons, 5 quintals, 21 kg, and 350 grams. And post-trial disposal is 9 tons, 3 quintals, 26 grams of more. And unidentified drugs, that is around 3 tons, 8 quintals, 65. With the total list plus 275 tons, 7 quintals, 13 kg, and 332 grams of ganja have been destroyed in the meantime. Likewise, brown sugar plus in total 75 kg and 0.77 gram and 400 milligram of.
Yes, just we'll be recording this part that you have done it.
Pardon.
We fix the matter for the further report.
Yes, ma'am.
In the meanwhile, Art Mr. J. Katokia, Learned Counsel, appearing for the petitioner. The petitioner has filed a compliance affidavit in terms of her order dated 3/4/20. No, it's not in court. Dated on 3/4/2023, dated 3/4/2023. In the affidavit, it is stated that 262 tons, 5 quintals, 21 kgs, and 350 grams of ganja in 1,679 cases and 75 kg, 77 grams, and 400 milligram of brown sugar in 37 cases as pre-trial disposal. Stop. 9 tons, 3 quintals, 26 kgs, 42 grams of ganja, and 94 kg, 494 grams of poppy straw in 94 cases have been destroyed as post-trial disposal. Similarly, 3 tons, 8 quintals, 65 kgs, and 940 grams of ganja were disposed of as an unidentified drugs being received from the district courts of Nayagar, Kalahandi, Kotak, and Bhubaneswar. So, in addition to those disposals and destruction, the authorities have destroyed 798 grams of opium in a case. As many as 24,330 number of bottles of codeine-based cough syrup have been destroyed in 25 cases. It has been further stated that those data regarding the pre-trial and post-trial, it has been further demonstrated by way of a table in respect of the disposal, destruction during pre-trial, post-trial, and identified drugs before 15/7/2023. At page 2 of the affidavit, there is a table, quote it. Stop. We appreciated the initiative taken by these narcotic disposal agencies.
By the police plus Odisha police.
Certain different levels in terms of the Mohanlal. Stop. But more rigorous steps are required to be taken to locate the narcotic materials stored in different courthouses or the places of seizure. So when those be immediately destroyed after taking the order of disposal from the concerned magistrate.
Yes.
Yes.
And plus, one prayer is that was while we are filing the application before the magistrate, that may be expedited. So that suppose within 15 days, people also direct. So the more number of, more.
Have you stated anywhere there is a taking time for disposal of such application?
No, that is up to loss because I am taking losses.
So somewhere you have to say that they are taking time because our experience is that the day when you produce those materials before them, they try to pass the order within 1 or 2 days. Even on the next date you cite an example, then we can pass the order.
Okay.
All right.
Obliged, plus.
But the matter be listed on after 15 days, any date.
Has this been e-filed?
Pardon me?
Has this been e-filed?
Yes, e-filed.
On?
On plus 27.
Let the matter be listed.
The date plus I have mentioned on that.
27th? 25th?
1979.
Statement regarding the disposal shall be filed by the
on 19th July.
25th of 8, 25th August.
Pardon?
25th August is the next date. Call the matter. This tells them
Scan and give.
why when e-file they are now scanning the papers. Tell them.
With e-file, they just have to attach it. Scanning is not necessary because it will come online. All the time they have to give. What is the use?
Yes. First mention matters.
And then those
WPCRL. Another matter was mentioned, 74 or like that.
Then WPCRLs are there. You take the WPCRL first.
Call the WPCC. What is your matter?
74.
70?
Read 74, 74. Lawsuit fixed to today from 27th.
This is WPCC.
Some delay was issued. 74.
74.
10 minutes, no. And
WPCRL starts at 78.
Miller?
Whether Mr. Mishra is available? Mr. Mishra?
Have you informed the other side?
Yes, I have sought a copy of the.
No, regarding administration of the matter because nobody
Yes,
can
on 27.
Not on 27. I was
not
talking
today.
about
It's not
today.
available today. I could not keep him on telephone and also he's not seen anywhere. When the short party, while dismissing the review petition, the honored single judge gave an observation which have included in this.
Oh. We'll take up a matter on 14th of August again.
It will be too late later because after the disposal of a first appeal, in terms of the observation, the company employer has filed another appeal before the Joint Commissioner headquarters of the Labour Commissioner, and it has fixed deal. He has condoned the delay without noticing me, accepted the award amount without interest, and admitted the appeal, fixing it to 5th August.
Now, what is the danger now that you are so eagerly pressing this matter?
Yes, after 9 years, I am yet to receive a sizable part of the PG awarded amount. It was out in 17. They did not.
We'll take up the matter on 14th August. Try to understand our difficulty also.
Miller?
14th of August.
See, Miller, I filed a press case for stay proceeding of the second appeal. Lordship,
already look into the matter. Stay. Since someone has passed the order without hearing on limitation, you are aggrieved. If we pass the order without perusing the papers, it will be very difficult for us to pass.
I have stopped a copy on him. The press case 4709 of 23. I filed on the last of the case. I mentioned it. Let the proceedings be stayed.
All right.
Till your lordship decide.
At 12. Let's this matter on 10th of August at 12 p.m. 12 hours.
At 2 p.m.
For hearing. Mr. Subrat Kumar Mohanty has appeared today for the appellant, and he pressed heard that the matter, that his claim is not being realized. Stop. There is a delay also in your.
Yes, delay notice was issued. They have appeared. All the parties have appeared.
Just a little for hearing and condonation. All right.
Well, I have filed a IA for stay proceedings before the.
No, we are not passing any order. We have passed the order for hearing and condonation. Let us see what happens. 10th, it will come on 10th of August, 12 p.m. It will fixed. Let us see what happens.
In the meantime, that may be.
First of all, on principle, I am against passing any stay order when you are late in the court.
Yes. Right? I have explained why I have come.
Because other party has also right of hearing because you are late in the court. Let us hear this matter on 10th. All right. All right. We pass the order. Ask this.
Do you apologize? I prefer a free copy of that. I prefer item 58. I prefer free copy.
Oh, a copy of the order.
Diploma.
32.
Is what happened in item 32.
728
You are not there. Other matters may not be taken up today.
Oh, sorry, my lord. Sorry. Yes. Yes, sorry. Oblige, my lord.
Yes, item number 32. Who is appearing? Any report, Ms. Patnaik?
My lord, item number 42. Item number 42, my lord. I'm appearing for the.
What is your
43, my lord. 43 Puri temple.
Puri temple is running very well. Don't worry. Every day there is an information.
They are not doing any work. Last from August 2018 till date.
We are fixing the matter on 14th August. 14th of August.
Oh.
All right.
24.
So sorry, my lord. Item number 42.
I'm coming.
My lord, item number 27.
42.
His name is 43.
Item 27.
No, 43 is there. 43 who is appearing.
42, my lord, I have filed my Vakalatnama on behalf of the OPSC. My name is not getting reflected.
43 Puri Temple, you have kept to 14th. So do gala na? 43.
What is the council's name, Mr. Mahapatra?
Yes. Mahanti, Mr. Mahanti.
My lord, item note 27, my lord.
Just
Item
take the number,
57.
item 43,
NK Mahanti.
ER NK Mohanty, and
Amicus
Amicus
curiae.
Curie for the petitioner. And Mr. DK Mohanty,
Yes.
AGA, and Mr. PK Paril, and ASG, DSGI for the opposite parties.
Item
My lord,
57.
24.
Item 42, what is the?
42, my lord, I'm appearing for the Odisha Public Service Commission. My name has not been reflected. I have already filed the Vakalatnama.
All right. But when you filed the Vakalatnama?
I filed the Vakalatnama, my lord, last week, but it has not come.
Which date? Which date? If you have filed on Friday, it won't come.
I have already filed the Vakalatnama.
No, if you have filed it on Friday, it won't come. So next date, it will come automatically.
My lord, 24.
Item 57.
Just Mr. B.A. Pradhan, no?
No, he's Mr. BP Tripathi.
BP Tripathi.
My lord, 24.
Just a minute.
24.
It has been stated by Mr. BP Tripathi and council that he has filed the deed of power for the opposite party number 3.
Opposite party number?
3.
For the Odisha Public Service Commission, opposite party number 3.
So registry is directed, if such deed of power is filed, to reflect the name of Mr. Tripathi and council as the council for opposite party number 3.
My lord, 24.
Deeply grateful.
Let the matter be listed on 28th of August 2023.
May I pray for item 57?
24.
Mention
So
it.
2 time.
It means 21st August.
2 time.
To remove the defects. Defects are there, you remove. It's for the appellant. Mr. NP Parija.
Mr. NK Parijal.
NP.
NP Parijal and its senior counsel has asked for a short accommodation. Let them 23rd.
My lord, item 27, my lord.
Let the matter be listed on 23rd August 2023. Meanwhile, the defects is identified. Mr. Parija, there are defects, you remove the defects.
I will remove defects 2 time.
In the meanwhile, the defects is identified by the
23rd August.
removed. Yes.
Item
My lord,
57.
29, my lord.
That is similar rule virus of that GRS matters. Let's say had the matter and today the interim order is operating today till date. Lordship may extend it, may be taken up next week any day or day after tomorrow.
Let the matter be listed on 23rd of August 2023. Interim order is passed earlier, shall continue till the next.
Item